Supplementary causeless. Pronouncement of judgment. Item number 1.
For what has been discussed about? Yes.
Your Lordship, I pray if this matter may be taken up for 2 weeks, Your Lordship.
No objection, Lordship.
Yes, the request made on behalf of Dr. Anmajika London DSG. This is matter after 2 weeks.
Which was, Lordship?
Daily causeless. Item
My
number.
apologies, Lordship. Lordship, I beg to mention item number 15, Lordship.
Yes, who is the other side?
Mr. P.T. Salman. Next one.
Yes.
Lordship, the Karnataka Council is on sanction leave, Lordship.
Who?
Miss N.G. Shillong.
What is the matter out, Mr.
Yes, Lordship, this is the actually compromise petition where actually there is a charge sheet. The charge sheet, the main accused is still absconding. Now, my lord, the question come, Lordship, because the
Just tell us, you see.
Lordship.
Other side is not here.
Yes, Lordship.
Just court need to know what is the matter. So
Lordship,
this is
Lordship.
a petition seeking quashing or proceeding on the basis of a compromise.
Yes, Lordship.
So when do you want it?
Lordship, after 2 weeks.
Lordship.
Any objection to his prayer?
No objection, Lordship.
You see, just a request has been made on behalf of MS NG Sillan and Senior GA. Paying for the state Rasamanet to adjourn the matter by 2 weeks. The Learned Counsel for the petitioner has no objection. The prayer alert, list after 2 weeks. You are also there, Mr. Sheikh.
Private husband.
You're supporting his case.
Lordship.
After 2 weeks, yes.
Lordship.
Lordship.
Item number 1.
May it please Your Lordship?
Yes.
Your Lordship, in this matter, I'm praying for some time, Your Lordship, as a conductor.
You're very high. His audio is. Please. Seems like as if we are in a public meeting. Still remains the same again. Yes, what is...
I am going to further say this report. This is against the needs the government and the employee to watch the FIR. The offences on the section 351 and 354A.
Well, if you can be... Well, it's still... sound still appears to be very loud, Mr. Very difficult to get what you're saying. Yes, what is the prayer is made now?
So,
Here,
Please
no,
don't
we
mind,
have,
Mr.
here, Your Lordship, we have prayer for quashing of criminal
That is all right.
proceedings.
Now, what the learned AG is making, the submission, what is the submission of the AG?
Your Lordship, we have received instructions that there was no compromise which was submitted before the lower court, Lordship.
So what?
I think as per the last date, Lordship.
So you have already your instruction.
Lordship.
So then, you will be filing any objection in the matter, or you would like this matter to be listed for hearing? Yes.
You are not making an objection, but no agreement in the court. When the status report reads the last time of the status report yes. Also, when you see the status report, there is no such compromise agreement and it's submitted in the
It's very difficult. It's very difficult to follow you, Mr. This is very difficult.
Sorry. Taking some letter to you.
Just if you can convey through your junior here, it will be better.
Yes.
Mr. Kumaran, I think.
The status report today.
So we'll do one thing. We'll fix this matter for hearing. That is better. Will that be all right?
Lordship.
Yes, Mr. Huh? Is it?
Yes, Lordship.
Is it? He agreed.
Yes.
Yes, Mr. Kumarsan. Yes, you have agreed. A submission has been made. No, you just say, Mr. So-and-so, learned AG, appearing for the state respondent submits that necessary instruction has been obtained in the matter. And stop. Give a stop. Submits. So you will not be filing any objection, but then it is not required. This is a criminal petition,
Criminal
isn't
matter.
it? Has a position and has submitted necessary instruction, isn't it? Submits. Do not say submit and submits that the matter can proceed for hearing. Stop.
Hey, please, Lordship. Lordship, if there's any requirements or final objections or written submissions, we can
See,
file that.
Mr. Karwan Lang, normally if it is a statement on fact, you file your objection, then the other side gets fair chance to counter it. But then at the hearing, if you place something which is basically based on your information derived from knowledge and all, then it will be very difficult. You can understand that if it is not a statement found in the records, then it will be very...
Lordship.
So if you want, then you can file an objection, then we will change the order, or otherwise.
Lordship, I think so. Lordship, let me just grant me 1 week's time so I can explore the possibilities.
Then you just change the thing. It has been submitted by the learned AG appearing for the state respondents that necessary instruction has been obtained in this matter. However, some time is required to go through this in.
Lordship.
Stop. He prays for grant of some time. Stop. The petitioner has no objection. Then you say next trial list this matter after a week. You just decide in a week.
Lordship.
All right.
Lordship.
Okay.
Go outside and communicate.
Item number 5.
Yes.
Please, Your Lordship. Lordship, in terms of the last order dated 4/3/24, Lordship. 4/3/24, Lordship. There were certain directions passed, and Lordship, the respondents were supposed to get
This order passed by Chief Justice.
Lordship.
Yes. What this order says, Mr. Chandra?
Lordship comes to page 2, Lordship.
Yes.
If Lordship allows me to read, Lordship, this second para, Lordship.
Yes.
The case of the petitioner is that even though the petitioner has been placed under not been paid subsistence allowance, which fact has been admitted by the respondent, non-payment of
The non-payment of subsistence allowance is admitted by the state. Mr. Karwanlal,
Lordship,
you agree to the thing.
Lordship, basically, as per
What has been recorded here, that you have admitted that no subsistence allowance were paid.
Lordship,
So that is a fact.
Lordship,
The
Lordship,
person who was suspended which year?
Lordship, he was suspended in the year 2003, Lordship, if I am
And
not
then
wrong.
till date, he has not been paid subsistence allowance.
Lordship.
Anyway, please continue. Yes.
Subsistence allowance vitiates the entire domestic inquiry, as has been laid down by the apex court in the case of State of Maharashtra versus Chandra Buhan Tale so and so 387. Since the petitioner has attained the age of superannuation as early as in 2012, and 12 years have gone by now, the question of putting back him in service does not arise at all, and remanding the matter is going to give rise to one more round of litigation. Hence, in order to give quietus to the matter, this court has suggested the counsel appearing for the respondent that the employee may be paid pension and gratuity alone for the actual services rendered by him. It is also suggested to the counsel for the petitioner that the employee could not insist upon payment of subsistence allowance and other benefits in order to put an end to the litigation. It is stated across the bar that during the pendency of the proceedings, suspension was revoked on so and so 23/5/2003. The counsel for the respondent sought time to get instructions and report the same on the next date of hearing, post the matter on so and so date.
So what is the position now?
The respondents were supposed to come whether they can.
What has been said, you will not be taken back to service.
Lordship.
That is what has been said.
Lordship.
Okay.
The benefits, Lordship, the only question remains is the
Counsel
benefits.
paid pension and gratuity alone. Yes. So that is the only thing. We will be. What you are doing then, Mr. Khan?
Lordship, the instruction that we have received after the court order was that because he was not a regular employee, it may be informed that the payment of pensionary benefits and other entitlements can be only made to permanent employees.
So what would be the consequence then if it is what has been held here, that non-payment of suspension allowance, if it vitiates the trial, then you have to take him back to service and pay him all the wages.
Lordship, so far subsistence allowance is concerned, Lordship, that part I think so they have a case.
See, subsistence allowance it has been said that his suspension was revoked on 23/5/2023. That means thereafter he should be treated in service. If the inquiry vitiates, that means you will have to pay his entire salary for all those things.
Lordship is correct. Lordship, we have just received instruction on that to that query, Lordship. I think so we need to file an affidavit.
Because this order appears to have been paid on passed on your admission that you have not paid subsistence allowance.
Lordship, yes.
I am not disputing this order.
Not disputing it because there's
Just take a decision what would be better for you. Just
Lordship is absolutely. We will try to file a Lordship. If you get instruction, we'll try to file an affidavit, and then only the limited issues would be as Lordship rightly said.
so have you received the instruction?
No, the instruction that we have received only was that since he was not a permanent.
But then you need proper instruction then.
Lordship, we need a proper instruction. Otherwise, Lordship, then. So, Lordship, we'll try to get more detailed instruction on that so that it will be easy. Otherwise.
So you have your instruction, then we will see whether affidavit is required to be filed.
Okay, Lordship. On that issue of subsistence. Yes.
Because if something comes out, that is better for you. You see.
Lordship.
Yes.
Lordship.
Absolutely.
Because the fact that with the subsistence allowance were not paid was something very unusual.
And
Of
Lordship
course,
is
probably he was suspended for a very short period.
short period. Lordship, we just need an instruction from the records as to
What about the decision of this 1983 SCC? That is the position of law till date.
which decision, Lordship, which part?
That verse has been referred here.
4324,
Okay.
page 2.
You see, the order passed by the Honorable Chief Justice has recorded that non-payment of substantial loans vitiates the entire domestic income. Now that has been said on the basis of a proposition of law laid down by the Apex Court, the decision of 1983. Now whether the position of law is same till today.
Lordship, I have to look into it. Lordship,
But then whatever it is, that has been recorded here.
that has been recorded. Lordship is correct. In Lordship, to my limited knowledge, what had fallen before, Lordship, if he is entitled to subsistence allowance and it has not been paid, then what Lordship said was correct. Then he'll be entitled to the entire salary. The issue of vitiating, subject to being corrected, Lordship, will not arise. Or only thing is this: if the court finds he is entitled to, so we have to first justify whether he was entitled to or not.
No, if there is a law which says that non-payment of subsistence allowance vitiate the trial, as has been held here in this thing,
And whether the law
then
stands.
that will be binding. Then your thing goes. Now, but the thing is that I do not know. Of course, this may become academic if these things. You see, like continuous suspension for a longer period of time without payment of subsistence allowance, and non-payment of subsistence allowance, say for a very less time. A person was suspended. Suspension was in operation for 2 months.
2 months.
That 2 months period he was not paid.
Correct.
Would it vitiate the trial? Vitiate the
Entire proceedings.
that is what I mean.
Lordship, the FR clearly says he'll be entitled to, like, supposing there's a 6 months period for completion of inquiry, and it does not conclude and it goes on for 1 year. Then the law is a settled position. Lordship, as per the law, is that he's been entitled to 75%.
That is all right. But then in case of non-payment, what is that? That is the main thing.
Non-payment, Lordship, is correct. Yes. What is the consequence of
That's what has been held.
If sum was paid, then enhancement to 75 is a different issue.
But though that the suspension is initially 50% and then 75%.
But Lordship is correct. Lordship is raising a
There
different
has to be
legal
payment.
issue. Lordship is raising a very important legal issue. Non-payment and what is the consequence?
And yes,
Lordship, we'll try to receive an instruction on that.
hard. Learned counsel for the parties. Mr. K. Khan, learned AG, submits that the instruction is set pursuant to the order dated 4/2024. Instruction pertaining to the order dated 4/2024 passed by this court has been received. Stop. However, it says the instructions were received is not sufficient. And does not fully answer the subject mentioned in the order dated 4/2024. Stop. Praise for grant of. How long you'll do?
2 weeks, Lord.
Weeks time.
We will try
To have more elaborate instruction. Stop. The learned counsel for the petitioner has no objection. Prepare a load list after 2 weeks.
Hello.
Item number 8.
to.
Yes.
Praying if this matter can be taken up next week, Lordship. Item number 8, Lordship, I'm praying if this matter can be taken up next week. Learned senior is leading us in this matter, Lordship. He has some difficulty, Lordship.
Yes, Mr. Khan.
Lordship, all very limited issue was involved in this matter. regarding subsistence right, whether they have a subsisting right or an enforceable right. And the records relied by private respondent clearly stated, an affidavit filed way back in 2022 clearly stated that they never had a subsisting right regarding the plot of land in Umpling.
Okay. So they never took over the position. The
They never took
allotment
over the
was not acted upon. Yes, then what remains for you?
Lordship is correct. Lordship, this has been falling from this court in last 3 occasions. What remains in the case? The only thing they required was
Let my
So,
senior
supposing there was an allotment, okay, and that there are evidence to show that you have never taken over the possession of the land subsequent to the allotment. So no right will accrue to you. What you are trying to implement?
And there was a limited issue in Lordship, and the records were relied. The record I had dealt at liberty at length. Sorry, Lordship.
So the
and
fact that the allotment was not acted upon
absolutely
has been brought into record.
by yeah.
And there is no dispute.
So then the hearing stopped in the middle because Lordship had granted at that time. They said they have not gone through the affidavits. Filed way back in 2022. Lordship granted that time more than 2 months back.
Okay.
So there has been 3 occasions where they have not verified the record, only on that particular issue. And it was heard at length by the petitioner counsel, Mr. Sukhdev was here, a very capable young lawyer. He had argued at length, and
So Mr. Chanda is also capable.
he's undermining his own capability. In the previous case, he argued so well.
Except the court, all others are capable. The court is totally dependent on the court.
Not at all. Lordship, we can assist the court. We know the other day the court was in the other side.
Yes, Mr. Chandu, then why should we drag it then?
Lordship may have it next week, Lordship.
That
I'm under
is
instructions.
the admitted position.
Let him just verify from
If
the
you can just
affidavit.
give us the outline, then what right you are seeking?
What is the subsisting right? That is the only issue.
Implemented through this. See?
I understand, Lordship, but Mr. Thapa is handling this matter, Lordship. Unfortunately, today he is not here, Lordship, due to some.
Take it, Lordship.
1 week.
If he has personal
indulgence,
difficulty, Lordship, we don't have any.
I'm seeking 1 week's
But
indulgence,
the only thing, Lordship, is that they have to verify that record and say whether this is. They only said they have not
If
gone
that
through.
point, see, matter comes to that short point, and if there nothing remains for you, even we can understand that, okay, counsel may have personal difficulty. But even if there is nothing to argue, then what is the question of keeping this matter pending? You can finish it by passing a short order.
Lordship, I understand, Lordship.
But Lordship, my lord,
Yes, Mr. Lindo.
Lordship, I have objection to the prayer that they are seeking time. Because it's a 2015 matter. Lordship, where they've been seeking time like quite
Any interim order here?
Your Lordship, interim order was status quo to be maintained. There was not extended.
Then the status quo is nothing.
Nothing,
Once they have not
yes.
taken position, then it's so.
Exactly.
That is a meaningless status quo.
Absolutely. Lordship had observed it was until further orders, and they never extended. Way back in 2015.
Yes. Then what remains? Then there is no difficulty for you, I think.
yes, sir.
Is it that the land has been allotted to you now?
It has been handed over, but I was not able to take possession
How?
because of
Why?
pendency of this writ.
Pendency is nothing. It's not a stay.
Yes, sir.
Doctrine of lispendence will not come here.
Absolutely. In the absence of any restraining order of the court. But Lordship, he has a personal difficulty, Mr. Sudev.
No, we can understand. You see, like normally this court would not like.
No,
to-
he is very lenient, Lordship. We understand that. Anybody can have a personal difficulty, Lordship. That's not the issue. But only provided the Lordship the next day let him.
finish it.
Lordship, next week we
Even
will
if
make
this
an endeavor,
matter
Lordship,
is- since you do not have to
take
wait
up this
for
matter.
Mr.
Lordship.
Tapao.
Lordship.
Positively, Your Lordship.
Next week.
Remind the court that it is at the request of the petitioner list of a week. Yes. Okay, after a week, 1 week.
Lordship, Lordship.
Yes.
I'll be back.
Item number 9.
What happened to Gopal Sinha? Gopal Sinha. Gulam. Please, go ahead. You're for whom?
Yes.
Okay.
Lordship, joint request. Actually, we wanted to mention in the morning, but I was a bit late. Lordship, joint request. May this matter be posted after 2 weeks.
You are appearing for?
Respondent 789, Your Lordship.
This. Okay, and what is the issue involved here in this case?
Lordship, the status quo of the matter has changed from when the writ was filed. They just
What
wanted
is the
to
matter
stay
involved in the matter? What is the case? What is the case about?
termination of Home Guard. But
Comes again the
as
termination order, Your Lordship. But during pendency, Your Lordship, two of the petitioners has attained superannuation, Your Lordship. So with regard to the two petitioner, we are on the monetary benefits, Your Lordship. Pension.
There are three petitioners in this
Yes.
case.
Three, Your Lordship.
So two already have
Superannuated.
superannuated. So the matter remains now. It is for proceeding for only in respect of one person, is it? Or
Lordship, with regard to two petitioner, we are on the with regards to pension benefits, Your Lordship.
okay. So all three are still there part of this.
Yes,
Lordship.
So that what remains that this termination is under challenge. Termination is by one order, by common order for all the three.
Separate, Your Lordship.
Separate orders. So then why one writ petition?
There's three
petition, Your Lordship.
So
connected.
this is termination on what allegation?
Lordship.
Termination on what allegation? What for? What? For what purpose you have been terminated?
Lordship,
Is it after the expiry of the time of appointment?
No, Your Lordship. Your Lordship, actually, there is an order passed by the Honorable Ghati bench, Your Lordship, stating that, I'll just take you to the order.
Just give us the facts. You see, like since you
Your
are asking
Lordship,
for-
it states that if the Office of the Accountant General Audit do not require their service anymore, we can't terminate. Your Lordship.
what is the mode of their appointment?
Your Lordship, there's temporary, Your Lordship.
Was it through a selection process?
No, Your Lordship, they were appointed on temporary basis by the Home Guard. Then they were posted.
By the Home Guard, the
Yes.
state government.
Yes.
Yes.
Then they were posted at the Accountant General Office.
Then it was whose responsibility to pay? This responsibility of
The
salary
Accountant
was
General is
the
paying.
Accountant General.
Yes, Lordship.
So their service was put under the Accountant General.
No, Your Lordship. It's just temporary basis. Purely temporary contractual basis.
But
Your
then it
Lordship.
was under the central government. So long
Only
they
for
remained
payment.
with you, you were paying their salary.
Yes, Your Lordship.
And you were regulating their service, isn't it? They were under your regulation.
No, no, Your Lordship. They are not. They have not been regularized.
No, we are not talking about the regularization.
Yes.
So long you remain in service, their authority, so long they were in service, their authority was under you,
Yes.
Yes, Lordship.
isn't it?
Yes, Lordship.
So it was only thing is that they are taken into service by the Home Department, but then the service was with you.
Yes, Lordship.
It remained with you.
Yes,
So
Lordship.
state has a lesser role to play. State,
Absolutely less.
no role to play.
Hardly no, any role.
And there is no prayer against you. So is it? Is it correct?
Lordship, what had happened, Your Lordship, in the year 2005, we came before the then Honorable Ghati High Court Generalization and for pay scale, Your Lordship. But to that effect, the court has given us only the with regards to pay scale, Your Lordship. But with regard to regularization, Your Lordship, court has categorically stated that as long as the requisitioning authority required the service of the Home Guard, we cannot be terminated from service, Your Lordship.
But Your Lordship.
So your service, the continuation of service on the dependent, it was dependent on the authority concern. So authority concern in terms in the say like it was the stipulation was that so long your service is needed, you will be continuing, isn't it?
Service of the Home Guard, Your Lordship.
No, but then how long your service should be needed or not, that is them.
Yes, Your Lordship.
So once they take a conscious decision, then what remains? Is it not that the earlier order covers up your case?
Lordship, it states that service of the Home Guard. It doesn't mention anywhere specific, Your Lordship.
So you want to say that once you are taking the service of Home Guard, if you are not required in Accountant General, you will be needed somewhere. You will be required somewhere else.
Lordship,
is it that?
Lordship, the order of the then Ghati High Court categorically stated that service of the petitioner.
That
cannot
order
be
is appended
terminated.
here with the
Yes, Your
petition.
Lordship. Yes.
Where is that? Just show us where is that order?
Page 18, Lordship.
Page
18.
Yes.
Lordship, objective paragraph. Lordship, if I may take to paragraph 17, page 29, Your Lordship.
It's a long order.
Yes, Your Lordship.
Page, what page will be relevant?
29, Your Lordship.
29. Yes, yes. Which part would be relevant?
Paragraph 17, Your Lordship.
Yes, and what is the finding of the court?
Page 32, Your Lordship.
Page 32.
Lordship.
Paragraph?
22, Your Lordship.
Yes.
Paragraph 22 and 23, Your Lordship.
Lordship, page 39, para 32 is the important finding. Page 39. Everything has been discussed in para 32. That's the finding.
Yes. So it is not a case that you have been replaced by somebody else, isn't it?
Your Lordship, and the same was not replaced by somebody else, Your Lordship.
Yes. Now,
And when it comes to the pay, Your Lordship, the one of the petitioners who's still serving, Your Lordship, their pay compared to the regularized home guard is double, Your Lordship.
that is okay now. See, we are not on the issue that what should be salary and all. We are not on the quantum of pay. What the court said that so long they are in service, they should be paid the regular scale of the home guard.
It's been
And their service can only be terminated in terms of the agreement,
Yes, Your Lordship.
which said that so long the Accountant General requests their service, they will continue. It cannot be a case that they have been terminated for want of having a regular employee. That also cannot be case. Okay. Now, but then once there is nothing to show that by replacing you, somebody else has been taken to service, there is no illegality in your termination. Then what remains?
Lordship,
And if you are not regular service, how will you become entitled to pensionary benefit?
Lordship,
How you will be entitled to pensionary benefit? It is admitted that you are not in regular service. Then
Lordship, the order category stated that we are to pay at par with the regular home guard, Your Lordship.
that is okay, so long you are in service. That means the benefits which normally a regular employee is entitled to, he also would get the same, irrespective of the fact that your service is temporary. Because that is what has been agreed upon, which you have pointed out is that paragraph 17, isn't it?
Lordship,
Now, what is your contention in the present matter? What do you say in the present case? What you are challenging and what is the basis on which you are challenging? That you are removed by what? Which order? Where is your termination order?
page 41, Your Lordship.
Yes. So after expiry of 1 month, your service stood terminated. And that is what was challenged. There is no interim order in this matter.
No, Your Lordship. There is, Lordship, there
So
is.
now, what is the ground of your challenge?
Lordship, the order category stated that it's not personal specific, Your Lordship. Because the requisitioning authority, as long as the requisitioning authority required the service of the home guard, Your Lordship.
Yes.
So
So that is why you see, like then in such a case, you have to say that by replacing you, somebody else has
yes, Your
been
Lordship.
appointed. That is where you said it's not person specific.
Lordship.
It's all right, we understood that. But then they have done with the service which you were rendering.
But Lordship, some similar set of employee were to replace us, Your Lordship. Some similar set of employee were to replace us, Your Lordship, which is in contrary to the
This
order.
could not chat what you are trying to. Some similar situated person, what?
Were to, if I'm being terminated, Your Lordship, then a similar situated employee, Your Lordship, will come in my place, which is in contrary to that order, Your Lordship.
Your Lordship, it's pertinent to mention that the 3 petitioners were the last home guard,
No, even if they are not last,
were the last, Your Lordship.
can persons similarly situated. Okay, and they start terminating from you. Can you say that so long others remain, I should also remain? Then there are 10 posts. It continued for some times. After a certain time, the Accountant General finds that 5 posts, service of 5 posts are not needed. They terminate those 5. Can those terminated person come and says, so long you do not remove other 5, you cannot terminate my service also? Can it
Lordship,
be?
but the others, Lordship, but the order of the 10 got the High Court, Your Lordship.
Yeah, what does it say? What order of the Guwahati High Court, what did it say?
Lordship, we cannot terminate from service until and unless we super annuate. Until and unless we super annuate, Your Lordship, or we may suffer physical disability, Your Lordship.
What the thing says? Come to paragraph 32, why not?
Lordship, para 24, Your Lordship.
Is validly terminated.
Lordship, if I may take to page 33, para 24, Your Lordship. Page 33, para
Page
24.
32. Para?
33, Your Lordship, para 24, Your Lordship.
This is judgment rendered before the.
It follows that unless any of the petitioners afflicted by any disease or become unfit for any other reason to retain in employment, he would be continued to remain in service up to the age of 58 years.
That is a normal situation. That is a general observation. That's all right. But then your service is guided by contract.
And the same, Your Lordship, the two petitioners were retired. They were retired here in the judgment. It mentioned 58 years, as in similar to the state government servant, whether disciplined at the age of 58. These two petitioners, Your Lordship, they retired at the age of 60. And one of the petitioners,
Because they were under your service. That's why.
yeah, and one of the petitioner, Your Lordship, had there's
So why you have allowed them
retired
to
at the age
continue?
of
Why you have
60.
allowed them to, or you terminated their service before that?
Yes, Your Lordship. Before that, we have been
Then how?
terminated.
Then what basis you have calculated their age of superannuation? Then?
Yes, Your Lordship. Is petitioner.
No, see, before they superannuated, before they even reached the age of 58 years,
Yes, Your
their
Lordship.
service to terminated.
Yes, Your Lordship.
Isn't it?
Yes, Your Lordship.
Then,
Your
then why? How do you say then how they retired at the age of 60?
That Your Lordship, their age was not clear, Your Lordship. There's no documents supporting their age.
Let
also, Your
us just talk about something which is admitted position. Okay, something which is not very. This court is trying to basically get is that what was the condition of their service.
Condition temporarily, purely temporary and contractual basis, Your Lordship.
That is what we could gather from reading of this judgment. What has been pointed out by him and Mr. Khan, that service was strictly in accordance with the terms of the contract,
Yes, Your Lordship.
basing on which they were taken into service. Okay. Now, out of the many stipulations, one of the stipulations said that in the event the accountant general decided to discontinue their service, okay, it should not be something like that they retain the post and discontinue their service only. No. When they discontinue the service of the post held by them,
Yes, Your Lordship.
they can be terminated.
Yes, Your Lordship.
Now your case is that yes, you have terminated and them, and in their place you have not taken
No,
anyone.
Your Lordship.
So what remains there?
Nothing remains, Your Lordship, since since we have not appointed any or in their post, anyone in their post.
Then
Lordship.
see.
Lordship, because there's a stay, Lordship. There's an interim order, Your Lordship.
Where? In this matter?
Lordship.
In this case?
That's why, Your Lordship, they've been
Yes. What is the interim order?
service. Continuous service.
What did the interim order say?
Order
Interim
dated
order
12
passed in 2015.
16.
2016. Okay, but then it is still the and then 12/9/2016. Then again. See, interim order was only till 21. It was not extended thereafter. Initially you obtained interim order, then it was renewed on the next day, and then therefore nothing. This Golab still is in service. He is in service. Golab Sana?
Pradeep.
Golab Sana?
Pradeep.
Pradeep Seth Sharma, Your Lordship. It's in WPC number 261.
Who is in service? Who have retired and who is in service?
Dhiren Chandra Roy, Your Lordship.
Lordship, petitioner and still in service, Your Lordship. And petitioner in WPC number 259 and 260, they have superannuated, Your Lordship.
Now, what is this order? I don't know. WPC note 259 of 2016 with so and so, so and so. Yes. See this? What is this? See this order sheet? What is this on the top? See the numbers? WPC number so and so with so and so and so and so. We reflect the same number everywhere. Yes, madam. Why you are asking time in this matter?
Lordship, my senior, Your Lordship, just received this matter just 2 days ago, Your Lordship. Before it,
There is a change of counsel.
Sir Akhil used to represent.
Mr. Devnath?
Yes.
Oh, Mr. Devnath is no longer central
Your
government.
Lordship, he's not a standing counsel for AG.
Okay. But then he still remain. He is still a central government.
Still can call me, Your Lordship.
Okay. Yes. What about her prayer?
It's a joint prayer and fact, Your Lordship. It's a joint prayer and fact, Your Lordship. In fact, it's a joint prayer, Your Lordship.
It is joint prayer.
Lordship.
Joint prayer to dismiss the matter. She prayed for dismissal of the matter. Okay. On the joint prayer of the parties, this matter. When?
After 3 weeks, Your Lordship.
After 3 weeks.
Yes, Lordship. We are still compiling some important.
Yes. Because you are continuing service. So you are happy. Yes, Mr. Khan, you do not have any. To say. But then you have taken them to service. The conditions stipulated in the agreement was framed by you. So you will have to explain it.
Lordship, since it's adjourned now, though, if Lordship would have seen the appointment letter, 16A. Both of them did not take a Lordship to the appointment. It's very, very clear. The appointment letter and the termination, the contractual relationship is clearly there.
Let them have another 3 weeks, then we'll see.
Oh, 3 weeks.
Okay, after 3 weeks.
Item number 10.
This which item? This will be item number?
9, Your Lordship. All the 3 matters.
Oh, okay, all are on. Correct the thing, correct the previous thing also here. Yes.
My lord, this is the matter where Lordship directed the party to respondent to provide the date of the award.
Yes.
Passed by the collector.
You have information about the date of the.
Lordship, we got the records, but unfortunately, Lordship, there's no date mentioned.
But then which way then we determine?
That is why we called the office.
There has to be something. You see, what is your thing version of the date?
So far record is concerned, Lordship, we can show the records. The original records.
See, if you could not determine it, passing it to the
record does not speak about the date.
We should know it.
Lordship, after going through the record and instruction received.
What for you wanted the date, Mr. Sangresha? Why that date became relevant?
In the course of the hearing, that issue came, and the Lordship put forward that question to the EAG.
What is the background of the
background of my lord, for expansion of the road, the section 4, section 6 notification already issued.
This
And
is a
my-
case where Section 9 notification was issued.
Yes.
Yes.
Section 9
Though
notice was given to me.
Section 4, Section 6, your name is not there.
No.
Section 9 was issued to you.
9 was
Yes.
issued to me.
But then
And
your
this-
name did not figure in the
Yes,
list of the names.
in the list, in both of the notifications. So therefore, I claim that my land is missing, and it is very much part of the acquisition area, and therefore, in that process, Lordship, the question of award came into issue. So Lordship directed them to produce the record, and instead of producing the record, they have given statement of award. That is not reflected there. Therefore, Lordship directed them to provide the thing. Only my Lord, they have given the
This is
list.
under the old act.
Old act.
Yes.
There was no reference after the.
That is exactly the issue, Lordship. Lordship, we stop at the point. If I may just clarify, Lordship. Yes, date is important. There is no doubt about it, Lordship. But more than date, Lordship, the very important issue was if Section 9 in Section 4 and 6 the name was not there. In Section 9 we have taken a plea. It was inadvertently issued, and he got a chance to file a reply, and he slept over and asked for a time and never brought in any documents. So then a situation came before the court that, okay, let us ascertain the award, whether his name is there in the list of award or not. So the records speak, Your Lordship, his name is not there. And it has fallen from Your Lordship because, as I admittedly stated, Lordship, no apology for that, the date is not there. But the subject matter is whether the name is there or not. If the name was there in Your Lordship, then the option is they can resort to Section 30. And if inadvertently their name is there and they have not got the amount, or the amount was given to somebody else, they can resort to Section 30 and claim the amount. But if their name is not there in 4, 6, only in 9, and the state has taken a plea, it was inadvertently done, and even in the award statement his name is not there, then the only option is if they have got a claim, then they have to go to civil court. So far,
But then before going to civil court, even if their name
Lordship,
did not figure in the list of beneficiaries, even then they can file an application for reference under Section.
absolutely. But Lordship, allow me to pause and clarify this matter. Now, what had happened was, when they filed an application, against the 9, when they filed an application, they had not any documents to show title documents. That was a vital issue. Similarly, even before this Honorable Court of Lordship, other than a mere certificate, they have not any documents to show.
Is there any period stipulated in law for seeking reference under Section 30?
Lordship, some period is
What
there.
is that? What is that period?
Lordship,
Was there any application filed by them for
No.
referring matter?
No.
Also, that situation did not.
That situation did not come.
So they are pleased
They are,
only on the basis of Section 9.
Lordship, yes. And now there are two very important situations in Lordship. Lordship could matter. Supposing Lordship could refer the matter on the basis of award and on the basis of an application if there was some supporting documents. Now that document is neither they produced before the authority nor before the court.
Documents of ownership you want to say.
Ownership, yes.
See, right now probably see like.
No,
may not
Lordship,
go
Lordship,
into
for a moment,
only
if you
thing
pause,
is that you have to counter.
then maybe he has got a case, Lordship. Now that stage also passed, and then we went to the next stage of award.
9 what he did.
He just asked for time, for a month's time. Nothing is.
For what? No, after Section 9, notice issued.
Lordship. Our plea is this, it was
Did
inadvertently.
he appear before the collector?
He just asked for adjournment.
We asked for adjournment.
And a month's time was asked, and then he did not follow up.
That is what your record says.
Lordship, yes. And that is the admitted case before this court also. There are documents. Now, after that, Lordship, then the award was passed. The Lordship paused at that moment when we were having a detailed hearing. Lordship paused, wanted to see the award, whether his name is there or not. If his name is there, Lordship, then the next course would be reference, or he has got a right to go to reference courts. Now, if there is no name in the award, what happens to him? Section 4, 6, nowhere his name is there. 9 was a kind of an aberration. We had rectified. He got a chance to bring some documents at the stage of 9. He chose not to after adjournment. Then he has not even approached the district collector like before passing an award. Kindly don't pass an award. I have got this document. And still, if he would have passed, he would have brought this document before the collector before passing of the award. And if that was overlooked, he could still have a right. First, before 9, he did not have any document. Even when the award was published, still he did not file any objection. After award, still he did not file any objection. He chose to come to the Red Court. Now, very, very important thing is this: where is his subsisting right in the writ
After
petition?
the award also he did not file any.
No.
He did not
No.
approach collector.
No. Now, Lordship, very important thing is this: if he had a document, then where is that subsisting right that he has? If he had a subsisting right on the basis of a document, then the Red Court will entertain. Now, if that right is not subsisting and he is claiming on the basis only of a certificate, the only document that is annexed is a NOCMA certificate to claim that he is an owner.
No, we are not going into that question of whether he is at all owning a land or not.
Absolutely,
The question is that,
absolutely.
question is that is basically what right is accrued to him in consequence of issuance of Section 9 notification.
He chose to waive that stage.
Otherwise, if you say that he has not filed any application making his claim, either before award or after award,
After award or
then there
before.
is nothing. There cannot be a cause of action for it.
Absolutely. Even after
The only
Section
thing
9.
is Section 9.
Lordship, we are highly grateful because Lordship had caught that very important point,
We don't
rightly
know-
or wrongly.
See,
Lordship
like,
is very
we are-
clear.
That is what your submission is. Mr. Sangresho is yet to open his mouth.
Lordship,
So probably he is sitting with a smile. You see, see that is the moment I stand up, then he will be dislodging you. So that is what.
No, but that is the only issue. What Lordship, let him confine his argument to the pleading. What has he done after Section 9? And after Section 9 and before award, what has he done? And how his right was either overlooked or not acted upon after award? There is no whisper in the reputation. Now, given that situation, that's why Lordship, I'm harping there. Given that situation, he has not taken any steps. First thing, had he taken steps, Lordship, then the state would have, whether the steps is based on some tangible evidentiary value. No, that stage is not before us. The second argument I'm not forwarding even.
What is the period prescribed for filing an application under Section 30? For seeking reference under Section 30?
Section 30, Lordship.
Is there any period specified?
Like some Lordship, some period is.
There is no.
Section 30, there is no period.
Section 30, no, Lordship. Section 30, no.
Supreme Court says
Section 18, reference, yes. Only for reference. Not
Section. Where is the acquisition? Which year this acquisition took place here? Which year? Just tell us. Is there any scope of filing any application for seeking reference under Section 30 at this stage?
that is for them to find a cause of action.
No, can he dispose of this thing, saying that he will file an application?
As per law.
As per law.
Last mean all other legal issues can.
No, is there any scope? After there is a delay, isn't it? This is a writ petition of 2017.
So far the present writ petition is concerned, there is no cause of action, but liberty can be granted to them to approach the appropriate forum.
See, that is what. See, there is no such thing. But then if any application is filed, that will be considered in accordance with law.
Absolutely.
Yes, Mr. Sangresh, what are your cases?
My Lord, I'll give a reply. It is very respondent that let them file application and we will consider in accordance with law. Now, I will stand on my own merits of my own case. I cannot rely on their witness. Lordship, the reason why Lordship directed the respondent to produce the date of the award. In the last occasion, discussion reached to a stage where Lordship put me a question, why you do not go for reference under Section 8? That was the first pleading made by the government from the beginning. And the learned single bench upheld that argument. We approached the division bench, and division bench set aside that if there is no award.
There is a single bench order before.
Yes, yes.
Where is that order?
My Lord, if there is no award, there is no question of, my Lord, landowner invoking Section 18. We may just come to that.
The order of the High Court.
My Lord, in the appeal. My Lord, division bench order is there, my Lord. The single bench order, unfortunately, is missing in my record. That was the argument advanced by the.
It's not a part of the writ petition.
My Lord, it is the matter. This writ petition was filed. And the single bench, my lord, passed an order that I should approach the.
No,
And
this is-
being agreed with that, my lord, I
Which-
filed
oh,
it.
this is the matter.
It is the same matter.
Okay.
And
Then
we filed an appeal.
can you do not remember the date on which the order was passed?
My lord, it is reflected here.
And you have a
Order of the division bench.
no. What is the order of the single bench?
Single bench, my lord. Now, single bench, I remember the basis of single bench. The single bench directed the petitioner.
We can just a minute.
My lord, it is reflected there also. And that was the argument of the learned EAG, that I should invoke section 18.
Just a minute. Section 18 is no question. 30. 30. Section 18.
My lord, I'm narrating the background. That was the argument of the learned EAG, that I should invoke section 18.
No, 30.
That is reflected in his in the order sheet also.
What's your order?
24/5/2017. Just a
And,
minute.
and my lord, single bench order was set aside.
Just a minute. We'll just say. Single bench order 24/5. 2017.
My lord, yes, in the order sheet may be able.
This is new. The single bench order said that you have not received adequate compensation. So your case was not with regard to the adequate compensation.
Exactly.
Your case is non-payment of compensation.
Yes, yes,
is it?
yes. Yes, yes.
Adequacy or inadequacy
Yes.
was not a question.
Doesn't arise.
So on that premises, I think
The single bench or order,
single bench order,
my lord,
it's a very short order.
very short order. My colleague appeared.
Probably one Mr. M. Prasad appeared.
Yes,
at that point
M.
of
Prasad
time.
appeared, and that
And
was
he
the argument.
He submitted the petition of grievance is that he has not received adequate compensation.
That was not his submission. Submission of the government side.
But then that
it
is
is
what has been
reflected in the
recorded.
order in that way.
Government submission is nowhere there in the single
My
bench
lord,
order.
my lord. Therefore, we prefer appeal. And appellate division bench, learned EAG,
Let us see.
argue that I should refer. I should invoke section 18. Lordship, kindly see the division bench order.
How many petitioners are there in your case?
My lord, here,
Four.
4 of them are here. 4 of them.
The division bench order says that additional synergy is a thing is a section 18.
Yes.
For reference.
He was praying for that throughout.
This cannot be section 18. There is no, the adequacy or inadequacy of rate is not a worse question.
Not
Yes.
My lord. Therefore, the question of Section 18 doesn't arise. And rightfully, learned EH is
But
not
in Section 30
pressing
remains.
that point.
Section 30 remains.
Yes. Therefore, discussion reached to a point whether Section 30 is available for me or not. In order to see that, appreciate that provision of law, Lordship pointed out when the award was passed. And the date of award was not pleaded in my case, was sourced in the account data. Therefore, Lordship directed them to produce a record. Now, record they produce, award is not, date of award is not there. Now, when we see the Section 30, Section 30 can invoke by a person when the award is settled. If the award, date of the award is not there, my lord, party cannot invoke. So it's also even the Section 18 also. When we see the language.
Section 18 is not at all.
Yes, not at all connected.
It's not coming here.
Yes.
We are concerned with Section 30.
Section 30. Lordship, can you see the Section 30? Before I take the Lordship to the record of the respondent. Section 30, madam. Dispute as to apportionment. When the amount of compensation has been settled under Section 11. If any dispute arises as to the apportionment of the same or any part thereof, or as to the persons to whom the same or any part thereof is payable, the collector may refer such dispute to the decision of the court.
That is exactly your cases.
But therefore,
you say that you are a person who is entitled to receive it.
Well, now in my case, my lord, here the language, when the award is settled, after the award is settled, my lord, then party can involve.
So, do you want to say that there's no award is settled here? In this case?
The record, it shows that there is no award. The record says, my lord, there is no date of award. And how can,
It means it is still unsettled, you want to say.
My lord,
have you paid compensation to any other person?
I'll show, my lord. They have released to some of the people. I have just referred to the letter submitted by the respondent. Lordship, can you see the letter submitted recently? They have mentioned the detail here. Lordship, can you see? I'll just take the attention.
Before we come to this,
yes.
Just tell us, consequent to the issuance of notice under Section 9, what are the procedure which has to be mandatory to be followed by collector?
My lord, so far
give us an outline of that.
My lord.
What collector should do?
My lord. According to my understanding, my lord, after Section 4 preliminary notification was issued, then under Section 5, right to be heard would be there. But since they invoked Section 17, that opportunity was not available.
Okay,
now
there's an urgency clause.
Urgency they invoke. Thereafter, Section 6 declaration issued. The moment Section 6 declaration is issued, the landowner cannot transfer or occupy the land, transfer the interest of the property. Now, after Section 6, they issue Section 9 to interested person.
Now, what are the procedures of Section 9?
Section 9, my lord. The Section 9, my lord, they issue notice to any interested person who has a claim over the land, maybe a owner, a person who claimed the ownership or the tenancy, whatever, any interested person. They can issue Section 9 notice, statutory notice, and hear the person who appeared before the collector, and after he can pass the award under Section 11. Now, until unless he has heard the notice of Section 9, collector passing an award under Section 11 is invalid, illegal. Now, in my submission here, they issue a statutory notice to me, Section 9, mentioning all the details of my land, my structure, the trees, how many trees are there. They issue notice to me. I appear on the date fixed. They did not call me. And therefore, they say that the collectors is busy. Whole day they waited. Nothing happened. They came back. And after that, my lord, they put up the application. That on the day you fixed earlier, we appear. You did not call us. Therefore, fix a fresh date for hearing.
That is what you prayed for?
Yes. They did not pass any order. Nothing. Therefore, we filed RDI.
These are all admitted positions.
My lord, they did not deny in their counter affidavit. I have annexed that application also there.
They do not deny that you appeared on the day fixed for hearing.
And they are not saying that even Section 9 notice was an error. Learned EHG advanced argument, it was by a bona fide mistake. It was not. They did not even revoke.
On that basis, can you interfere with the award?
My lord, here no award is passed in my favor. My lord, the question of therefore pass, I'm not praying for setting aside the award. But My humble prayer is that my land has been vanished during the acquisition proceeding, and the collector, who is the acquisition authority, has flouted the rules, never gave me opportunity, and in that process my land is missing. And therefore, we invoke the lordship jurisdiction. Now, therefore, they have submitted the letter, a word statement, and others, the list of the recipient of the amount. Now, Section 4, Section 6, notification issue, but the award that appears to be finally passed is under the new Act, 2013 Act. It reached earlier, it was 55 lakhs, the total compensation, but after arrival of the new Act, they reevaluated, and it seems that they have passed amounting to 8 crore or something. So out of 8 crore, 3 crores they have released, almost. Remaining 5 crore somethings are pending as per the noting of the letter in 50. Now, in the list of the recipients of the amount, Lordship directed me that you go through the paper submitted by the government and where your land is located. Now, I can easily point out my land is near to which recipient.
Was it that to that extent to find out the location? I do not know. This is the writ jurisdiction. Probably this is not our work to go and find out the location of land.
Therefore, my lord.
See, what was basically probably that is how many claimants are there. What it?
Yes. Right.
And whether that has that amount has been dispersed or not.
Yes.
That is the main thing.
Good.
Now, there is no date reflected in the award. Now, in what happens in which way you assume the date of award then in such a situation?
That is why, my lord. That is
so. What would be the position of law in this thing?
My lord. Therefore, even assuming that the lordship is kind enough to direct me to invoke Section 30 at this stage, the date of award is essential.
Yes, definitely.
My lord.
Definitely.
And the records.
See, this court has not finally decided that whether this court will direct you for Section 30 or not. First, this court will have to determine that what right is accrued to you, right, in pursuant to the issuance of Section 9. Now, that is what is the prime thing which you have to establish before the court. Right. And then second thing is that, of course, if you say that yes, that even if any Section 9 notice is issued to you wrongly, even then also you deserve a chance to get a hearing.
Right.
Even for the purpose of determining that you are not a you see, like a required person.
Right. Collector could have said.
But then once Section 9 is there, that was your duty to give you an opportunity of hearing. Now, if you say that you appeared on that day, and then they did not give you time,
and the next application put up,
and then subsequently they proceeded to prepare the award,
it appears
without giving you an opportunity.
Yes.
Now, what would be the legal consequence of that?
Well, therefore,
no, you just tell us what would be. Say, supposing if you are able to establish your case, that Section 9 you appeared, you were not given a chance, okay, and then in spite of the fact that you should have been heard, they proceed ahead and prepare an award. Then what would be the consequences? Now, what direction we can issue at this stage to correct that?
My consequence of issuing a Section 9 notice to me and not hearing me, at least the recipient of Section 9 notice.
So that means,
they have the right to be
do
heard.
You want to say that we should give them you should direct them to hear you?
But that is one option. And second is, my lord, since lordship.
See, one thing is one thing, Mr. Sangreshu, we cannot pass any order directing payment of compensation to you.
Yes.
That is yet to be. We have not gone to that stage.
Right.
We are at a stage where your right is yet to be reserved under law.
Right.
Now, in that situation, say supposing if you are able to make out a case, what kind of direction this court can issue?
Well, my humble submission would be, lordship may direct the collector to hear me. On the day of hearing, we would appear and satisfy that this is my land. Prima facie. Collector is not authorized to decide my title, but for his satisfaction.
Now, this is the pre-award situation.
Pre-award situation. And
now, say supposing collector hears you, and he finds substance in your claim.
Yes.
then award will have to be modified.
He has to.
Can it be?
My lord, according to me, my lord, if somebody's land is missing in the acquisition proceeding, and
Once-
the collector come to know,
Once a proceeding attends, can collector retouch it?
my lord, but so far as the other landowners, he will not retouch, and no one has a grievance. But so long as the citizen,
Mr. Sangresho, it is a question of law. We are not, it is just, this court is not putting you a query to make a good adjustment, a sound, and you see, like justify, we are not on that. We are saying that once a proceeding culminates,
yes,
subsequently, can we reopen and go back to pre-award stage?
but according to me, my lord, if I may,
You have any proposition of law?
my
to
lord,
show that
my lord,
in the event it is allowed.
Yes.
You see, it is not that the court has accepted your prayer.
yes, yes,
First, what is required is that determination of your right consequent upon issuance of section 9.
yes, yes.
Okay, what is the consequence of not affording you a hearing as per stipulation of section 9? And then, if at all, if you can make out that it is mandatory that you should be given a right, you have a right of hearing, then what effect it would have on the award?
No,
And even if you can, if say supposing if your claim becomes acceptable, then whether that award can be modified or not.
but there are some cases where even, my lord, in the stretch of many landowners involved, some receive the award, my lord, some of the people did not receive it, and even they did not get avail the opportunity. Cases, my lord, where Supreme Court laid down, even directed the collector to pass a fresh award. Those judgments are also there. I may place in the next occasion if Lordship permits me. Now, therefore, in my case,
Now, see, Supreme Court's power is something different.
my lord, Lordship is sitting in a rich jurisdiction.
No, that is we can
Well
understand.
powered,
But
my
even
lord.
sitting in REIT also,
Yes.
they have this what is it? 140,
141, my lord.
141.
Yes. That is there. That is there.
See, something kind of usually like unlimited jurisdiction to justice in a case where it is not contemplated in law. You see, like, so that is even law may not allow such things, but then for interest of justice they can do it.
Right.
We do not have that much.
That is
Now,
true.
what this see, this court's query is, you see, like probably you have already got it. See, like pre-award stage and post-award stage, there are two things. Now, if you come to section 18 and section 30, these are post-award stages.
Yes. Yes.
Okay, section 80 concerns the adequacy of right.
Right.
Section 30, where like
Apportionment.
person like you,
Yes.
who comes and says, no, I am entitled to get the compensation, you have not paid me. Now, for that, procedure has been laid down. But then there, the collector refers the application. He doesn't do anything by himself and waits for the outcome of the decision of the special judicial officer.
Right.
Now, here, you are here at a stage which concerns pre-award stage. Now, if any direction is issued, that has to be issued to the collector. Now, the lawfully, what this court can issue, what direction this court can issue, what would be the limitation of that? Can the court say, no, you here, Mr. Sangresho, then you accordingly review your award and pass a fresh award?
If I satisfied, he would pass the award. If not, then he may refer.
See, if it comes to that, the portion of land which you are claiming, the compensation for that amount is paid to somebody else, then what happens?
But in that case, my lord, those who receive, perhaps they claim that in my land, so then they will come forward and claim it. Then
At
matter
what
will
stage?
go to civil court or the
Where?
reference court.
Can everything be done before the collector? Cannot be done before collector.
That is true.
These proceedings happens in the court of the special judicial officer.
But therefore, if
That is what the
anyone,
problem is. We have to understand our limit.
that is why, my lord, if the collector give me opportunity, we will appear. And when we appear, he will pass the order. If he satisfies, then he'll pass the order that yes, you entitled. I will pass a word in your favor since your land is there. He can pass a word.
What is the actual amount allocated in this thing?
Well,
What was the actual
a word.
sanction? What is the total
sanction
award
of the
made,
project.
what was the amount estimated initially? You see, before award is prepared, some estimate is prepared.
But,
How much money would be needed?
but he did,
Accordingly, deposit is made by the requiring department,
yes,
isn't it?
yes,
And the kind of compensation is therefore decided. You see, basically, before an amount is paid, the assessment is done,
yes,
and the market rate is taken into consideration, and thereafter a reward is prepared.
yes.
Now, the query of the court is that what was the actual amount earmarked for the compensation, payment of compensation, and what was actually paid? Is there any surplus? No.
No, no, no. What happened as per the
In this case, present case, is there any surplus amount? No.
it appears
Which
that
was returned to the department or something
No,
like
no.
that? No.
no, as such. Because that since they initiated under the All Act, the initial estimates was perhaps 55 lakhs. Subsequently, my lord, before they complete the award proceeding, new act came into being. So therefore, they reassessed the compensation under the new act, and it has escalated to 8 crores.
Yes. It
And
means
out of 8 crores,
accordingly, they have procured that extra amount
yes,
from the department.
yes, from the department.
Isn't it? For
Yes.
payment of compensation.
Yes. So out of 8 crores,
Yes.
they have first released 3 crores, 3 crores 65 lakhs something. And 2015 letter say that the department has to provided additional 5 crores 95 lakhs something, so that they can pay. So till 2015, in their own showing record, they are yet to pay the larger amount of money to the landowners. And now whether they have paid, I was informed recently by my party that maybe last year the collector called those people to receive the compensation.
It means you want to say the whatever total amount awarded has not been dispersed till now.
Yes, yes. Well, in 2014-15, they say that they released 80% of the amount. Now they release the amount, and subsequently they reassess under the new act. And under the new act, and the collector call upon all the landowner to come and receive the new assessed amount. So even the latest report submitted by the learned EAG, it stated the same thing. May I just
The
invite
total
Lordship
amount
attention?
of compensation has not been paid.
You really pay or not?
Of
Lordship,
course,
kindly see
I
the
do
letter.
not know how much relevant those queries would be. But then what this court is trying to formulate is that in the event, if it is sent back to collector for reconsideration,
Yes.
what relief you may have, that is the main thing.
In my case, my lord, I, like other landowners who received the Section 9 notice, I would also appear. Well,
that is okay, but then can award be modified?
my lord, my humble submission is collector has every right to pass the award if he appreciates.
No, award is already the query of the code is that Section 11. Wait. Come to Section 12.
Yes. Section 12, yes. Award when to be final.
Surplus 1.
Yes, my lord. Such award shall be filed in the collector's office and shall accept as hereinafter provided the final and conclusive evidence as between the collector and the person interested, whether they have respectively appeared before the collector or not, of the true area and of the value and apportionment of compensation among the person interested.
So
But
that means award will have application on a person who has not appeared before him also.
Well, now it
So
is
let us see, if you have not appeared before the thing, then only courts will be open to you is that section 30, nothing else.
even section 30. Therefore, section 30. Therefore, last time Lordship pointed out section 30, not section 30, when the award was passed.
No.
Now,
When the award was passed, but then see here, of course, we can say that there is no date in the award, but then the fact remains the award is there.
Lordship, can you see the paper document submitted by the collector?
See, section 30, which is basically with regard to reference. Now, section 12 gives an understanding that irrespective of the fact whether you appear before the collector or not, this award will apply to you. That is the final proof of the apportionment or the claim. That is what.
In that case, my lord, the consequence
And
of
if
this.
anybody still has any cause of action after this, section 12, then so far as your thing is concerned, it is section 30, what else?
Section 30.
So now, did you file any application for reference, seeking reference of this
No,
matter?
I did not file. I did not file. Because on the day they issued notice to me and did not hear me, subsequently we put up application for fixing a fresh date.
But the section 12 covers up that issue. That whether you appear or do not appear is inconsequential.
It is not a matter we can appreciate. It is not the case of the respondent. That your land was taken away, you are not
That is what
appearing.
the law says.
But
See, kindly appreciate. The language used in section 12 basically speaks of a person who has appeared or who has not appeared. It says irrespective of the word. Such award shall be filed and shall accept as herein after provided.
no, except as hereinafter provided. What are the provision, my lord? We read down. Collector shall give immediate notice of his award to such of the person interested as.
Just tell us one thing. Now they have taken a stand that you see, like the issue of section 9 notification was a mistake, isn't it? Did they pass any order to that effect?
Nothing.
Mr. Khan, is there any order that you said that this is something new?
Yes.
Lordship, that order was not required. If I take your Lordship to
Was there anything? Say, rightly or wrongly, you have issued a notice, section 9. Now, thereafter, is there anything to show, as you have contended, that it was wrongly issued to you? Any order to that effect?
No.
Now, it means the person's name remains in the list till the stage of section 9. So he is considered to be a person interested.
Lordship, his name was not there in 4 and 6. It came for the declaration which contained the final list of landowners interested parties based on report of EAC. Now, EAC is the EAC, Extra Assistant Commissioner, was the authority who was supposed to evaluate, who was supposed to prepare the detail before declaration was done under 4 and 6.
Yes, then what remains, Mr. Sangreshu?
And Lordship, another aspect, Lordship.
Pointed
Let
out.
me just complete. Lordship, just come to page 129 of the writ petition. What happened after section 1(9) notification? See the conduct.
Just a minute. There's only one affidavit in opposition. Only one affidavit in opposition.
We've taken a plea in paragraph 15.
That is what you have read out just now. Now you are referring to?
Now I'm referring to writ petition page 128 and 129. Worship, relevant page would be 125, Annexion 9, Mary D. Marak.
Yes. Form 2. Annexion 9.
Annexion 9.
Yes.
Worship, kindly see the name is Srimati Mary D. Marak. Notice is hereby given
Yes.
on top. The second line, trees blank, Pakka structure blank, Pakka Assam type. The only word that we can find is 2.
Assam type 2.
2. Assam type 2. And all other things are blank.
No, but then that is you say on the basis of the district council information.
Yes, yes. I'm coming to the other explanation. The purpose of this is a blank notice. Nothing detail is mentioned. Rashid, the date is very important. All interested persons in this land are hereby called upon to appear personally or by agent on 19/7/2013 at 11 a.m. Rashid, date is 19/7/2011. No, they have never appeared on 19/7, Rashid. Now, how do we find they've never appeared? 19/7, then 19/8, they slept over. They woke up only on 13 September. That is at page 129.
Just a minute. Just 19/7, you say they did not appear.
They were supposed to appear on that date.
They did not appear.
It's by their own admission.
How do you say?
Lordship, page 129, Annexure 10. So 19/8 they slept over for 1 month, and they woke up only on 13/9.
Just a minute. 129.
Annexure 10. So an argument has been forwarded that no opportunity was hearing, some order should have been passed.
Yes, this is.
This is to Deputy Commissioner. Date is important, Lordship.
Yes, 13 September.
13 September.
Yes.
So after 19 July, 19 August, and then 13 September.
No, but then is there any statement that they did not appear on this?
Yes, I'm reading on. Lordship will find there is a statement. They've given some justification, but Lordship will come. Let me. That is at paragraph 3. But let me just read from the top.
Yes, yes.
With reference to the subject cited above, we so and so, so and so, so and so, residents of so and so, under so and so, so and so, have the honor to bring the factual grievance in few lines, stating as hereunder that we are genuine owners of land situated at Songha, Rangna, under the said so and so. Due to ongoing construction of Tulini, Shillong, Nongsten, section of Naitri Highway and Nongsten, so and so, Tura Road, under phase 1 of SARDP-NE, under Act of 1894, our land was being encroached for the reasons of which we have enlisted in serial number 45, 48, 49, 50 to receive the compensation. That being called upon by the letter memo number so and so 9th July 2030, on 19th July 2030, we have turned to the concerned authority for hearing. We have been aggrieved to return information from the concerned authority that the list of inclusion of our names in the statement of valuation have found loss, and we returned without attending the hearing. No, they have.
So it is not at all a case what has been said that they have not been attended.
No, it's their own admission, Your Lordship. They have not mentioned which authority, but they have written to DC because the documents were lost. We don't know what documents, no specification, so they did not attend. That we have approached the dealing authority.
We have been aggrieved to receive certain information from concerned authority. Now, who is that concerned authority?
We don't know, Lordship.
That the list of inclusion of own names was found lost. Okay.
List of inclusion of our names in the statement of valuation was found lost, and we returned without attending the hearing.
Yes. So that is returned by voluntary. That is a voluntary decision.
Voluntary disclosure, Your Lordship.
I mean, like that to return from there, it was a voluntary decision.
Yes. Without, and the word used is without attending the hearing. And it is that we have approached the dealing authority and requested them to search for the lost list. So when you're talking about the concerned authority, they're talking about the dealing authority. On being asked repeatedly, the dealing authority have searched for it, and we have been informed that the lost list of inclusion of our name is found. Having found the list, and as DC in charge for the revenue is also transferred to pursue the work without delay with new DC in charge, we submitted application. We're talking about this application.
Okay.
The above stated facts and circumstances, we aggrieved landowners sincerely request Your Honor to kindly fix another date for hearing and to compensate for the enclosed land, for which act of your kindness we shall ever remain grateful. in support of your application, so and so.
Now tell us, it is 13 September 2013, whether your award was prepared before that.
No, award was not prepared.
Then he could have given them a chance. What is the problem? Then he could have given them a chance.
Lordship, absolutely correct. Now the situation is this: this was considered. This letter was submitted after more than almost nearing 2 months. By the time Section 9 proceeding was completed,
He could have treated it as an application under Section 30. Could have referred it under Section 30.
Lordship is correct.
Had there been an award by that stage?
No, award was not there. Lordship. Award was in 2000.
What is then? Which way you have responded to this?
No, we have not responded. We have chose to completely, Lordship, not to address this letter because by the time Section 9 stage was over and we are proceeding in Section 11.
You were proceeding, but then until and unless award was prepared, you could have considered it.
Lordship, because there was no requirement, Lordship, because you see the contents of the letter. There's nothing.
That becomes a question of merit. You see.
Yes.
You could have rejected it by saying that there is nothing.
Lordship is correct. We checked.
We have not done that.
We have checked.
Now the problem is that I see day of award become relevant here.
Yes.
For determining this, once you basically receive a representation.
No, the Lordship will kindly. That's why I said kindly see the date. What is Lordship is saying is correct. I'm not denying it, but we have checked the record. Now our stand was this. Our stand so far, the declaration was concerned. It was based on EAC, and inadvertently GADC's report on the basis of notice was issued. And by the time this letter came, everything was issued.
This was
2013. Yes.
Situation remained. Thereafter, nothing happened.
There was nothing
The
happened.
parties were marked. When did you approach this court for writ petition?
Yes, 2017.
What you were doing the 4 years? Mr. Sangresh, 4 years time?
And Lordship will kindly appreciate. I'll just.
We obtained the information, and we filed the writ petition.
See, your last representation was 2013.
Yes.
It was not acted upon.
2013, because the compensation was not at all finalized.
No, when this compensation was finalized then?
That is why, my lord.
When this compensation was finalized?
Finalization, Lordship, we can produce a record. This is
What is the date?
Lordship 2015, not specifically, but it's slightly unfortunate, Lordship. I don't know why the dates are missing.
But then this becomes a battle thing now.
File notings are reflected. I can produce the original record, Lordship. I have the list. The statement of award, Lordship. At least I can.
The statement of award, I think you filed earlier, isn't it?
No, but from the records. Lordship, before I come to that, Lordship will kindly see even the prayer. Very important. Had the prayer been, Lordship will just come to prayer. In the meantime, I'll just get the record. Page 21, Lordship. Now, if their prayer is that because no hearing was done under Section 9, so mandamus should be issued, allowing them to hear the matter and set aside all the subsequent.
See, that is why you see, if had there been the subsistence of continuations of the period of Section 9, maybe there could have been a thing.
Yes.
Could have passed a direction that considered their application.
No, Lordship, yes.
Once we stage it, can we revert back to Section 9?
No. First thing is this, Lordship. If there was a prayer for that, then I would have got a chance. Lordship will kindly see what is the prayer. Now, if there is no prayer, and an oral argument has been submitted on the Section 9.
What is the prayer?
Lordship will kindly come to page 21. Setting the clock back after Section 9. And to set aside the award or to keep
Yes,
pension.
what is the prayer here?
In the premises, Lordship has got it.
Yes.
In the premises, it is prayed that the Lordship be pleased to admit this petition, call for records, issue rule calling upon respondents to show cause as to why. Writ of mandamus should not be issued to direct the respondent state to take immediate steps. Direction is for the state to take immediate steps and pay suitable compensation to the writ petitioners from acquiring over the land and the land, Assam type house, tree situated so and so, is garnered within a reasonable time frame as per provisions of Land Acquisition Act, along with interest, if any, and further be pleased to pass such order. Worship, two things is very important in the prayer. First thing is they are asking the state to pay suitable compensation. Number two, Your Lordship, they are asking the state to pay suitable compensation, whereas the law is otherwise. If for some reasons, after the award, if they have not got the compensation, they have to resort to.
Reed Court can mold relief, why not?
But
To some extent.
Lordship, Lordship, I'm aware of the proposition of law. No, but here the specific prayer is suitable compensation as per the Land Acquisition Act. Now, if I say kindly grant me relief as per the Constitution of India, then court will not make a roving inquiry, Your Lordship, into which provisions of law. Whereas an argument has been forwarded only on the specific.
This thing, basically, this situation would not have arisen, would not have come to that had there been a mention of award in your thing.
Lordship, we have submitted, the date is not there. With all
If
humility.
the date is not there, then how do you know when this award was prepared? Would you to assume till date you have not disbursed the money, the entire money? Then?
No, but Lordship, that is not the subject before this court. I wish I could have replied.
The kind of
the only subject, Lordship, is whether the clock can be set back after the stage of Section 9.
See, Section 9, they do not want that thing also, that there should be given an opportunity to hearing. As you have rightly pointed out, that their prayer is with regard to the payment of compensation.
Payment of compensation.
They do not say that we should be given an opportunity of hearing.
Lordship.
Yes.
No.
But then looking at the situation, probably we can mold it to that extent. But then the question is that when it is pointed out that award is in existence, can we go back?
My respectful submission, Your Lordship, would be no.
That is what?
No. Lordship, if you want to address that.
But then, at the same time, can we deprive them of a chance,
Lordship,
which is contemplated in Section 30?
Lordship, no.
Now, you may well say that they have not filed any application.
Lordship, as I submitted, Section 30, as I submitted, initially, Lordship, before the lengthy argument took place, I submitted that there is no cause of action in this writ petition, because the most fundamental thing for this writ petition is this: they have not produced any documents to show that they have got a subsisting right for this court.
For reference Section 30, that is not needed. That is not determined by prima facie requirement.
No, Lordship,
the claim is enough to go.
Lordship, absolutely correct. No, that's why I submitted that if court wants to mold the relief, liberty can be given to them to approach Section 30, but as per provisions of law.
See, but then the question is that question remains: is that the Section 30 basically would arise when the award comes on a definite date. At least we can say that they have the information of the award. If you do not have a date in the award, which way you determine that on which date?
Lordship, they'll have a benefit of limitation period not coming in the way.
Limitation, where is the question
for some reason,
if Section 30 doesn't prescribe any period.
So even if Lordship, even if there's a delay, they'll have a benefit of that. But now, Lordship, another important aspect which has fallen from your court was 2013, the application, we chose not to do it. But there is no whisper for 4 years how they slept over it.
That is what the things. You see, there is
another aspect of the matter.
There is a negligency on their part.
And there is no whisper.
Now,
no whisper
to hold them. No, just a minute. Just to hold them, the guilty of delay and laches. Then in such a case, it is required for us to first establish the date of award, so that we can say that he was sleeping over his right for 4 years or 3 years at the case.
Only on the representation, Lordship, not on the award. Court can hold, because non-application of date, the court is not in the position to really appreciate the issue of law. But the issue is this: if that application was not considered, no order was passed. It's not about the.
What is the date of publication of your award? What is the date of publication of your award?
We don't have the date. The request
that is a problem. Then how you expect one citizen to know about the award on a particular date?
Lordship, the issue is not. The issue is, unlike we had this argument in Prakash moment, Lordship. Perhaps that is the background that's bothering us.
What is that Prakash moment?
Prakash moment, we had the issue of date of award. and the issue of limitation. Lordship had dismissed that petition.
There is a land acquisition matter.
Yes, very, very
Decided
intricate
by
issues of law. So, in this case, Your Lordship, it is not their case. That's why I read out the prayer. Now, if you read the prayer again, once, twice, thrice, we can come to the very clear conclusion. It is not the case that they could not.
The decision of Prakash Momin was not challenged.
No. So that's a landmark judgment Lordship has held, and it was a very lengthy hearing.
This is the one thing, but then the here problem is that
there was section 18 where the issue of
just a minute.
Absolutely.
Before you address your argument, just what would be just better, basically to disclose you what is there in the mind of the court. There are two aspects from the facts and situation of the case. That the relief which the petitioner may be entitled is that send back him to the collector for consideration of his application or for giving him a hearing under section 9. That is one thing.
Yes.
But then the fact remains that award is already in existence.
Yes.
So that situation is over.
Lordship read out section 12.
Now
yes.
that is gone. Section 12 says that this award will have a binding effect
Faith accompli.
on a person who appears who doesn't appear.
Absolutely correct.
So he will be bound by that.
Absolutely.
Now the thing is that
we don't know the date.
That is what the problem.
No, Lordship.
Even going by that, then one option remains with the petitioner. Still, for advancing his claim is the section 30.
Yes.
Now, section 30, for availing section 30, it is
no limitation. No limitation.
There should be an existence of award.
Yes.
Now, just to hold that there was an existence of award, as you have produced it just now, we know it. But then how to basically hold it that at the time of filing of the writ petition and all, the petitioner was aware of the award.
No, Your Lordship, that award, since we have brought it to the notice of the court. And
what about his statement in the writ petition? Does it say that he was aware of the award, passing of award? Here?
No.
Is there any whisper?
No.
No, but then once he has made a prayer for compensation, definitely there must be a whisper.
Lordship, we kindly appreciate. He has not forwarded the argument. It is not his case before this court that because he doesn't know the date of award, he could not invoke either 18. The Prakash Momin was hearing on 18 because of the limitation applicable.
That was Prakash Momin, this because limitation was provided.
Yes, and we had a lengthy hearing with what to do with limitation, how to overcome. No, in his case, it is not the case that he doesn't know.
Prakash Momin is the case where Mr. Diengdo appeared.
Yes, and he relied on a Supreme Court judgment. Lordship had disagreed with the Supreme Court judgment.
Is it?
Yes. But seeing the facts of the case are not applicable.
This court disagree with the proposition?
The facts was distinguishable.
Okay.
The facts was.
So you can say that this court has disagreed on the application.
Yes, per inquiry.
But do not say that that is something will be very.
On facts, the law was distinguishable.
Would you say that in facts and circumstances?
Absolutely, Lordship is held there. Lordship, I'm sorry, Lordship. Maybe your choice of what.
See, you have made this court nervous by saying that.
Lordship, you were enlightened because court dealt in detail how the facts was distinguishable. No, and the biggest hurdle was to overcome limitation.
Here, see, one thing is Mr. Sangresha also knowing very well there may be a prayer in his things that this court at this stage cannot pass an order directing payment of compensation in his favor. That is something
he has a statutory at that date.
Okay, in the facts and circumstances of the case, we cannot say that how much load he is having, how much, what property was there.
Yeah, absolutely correct. Okay. That part we are not going. We are not going. Very limited issues. We enter a very limited issue.
At the best, if says this court finds that somebody is entitled, they may direct the collector of the situation and pass this.
Yes.
Now here this dilemma is that here you see, here the petitioner has not come to this court saying that see, I have made a claim to the collector.
Yes.
And he has rejected my claim.
Absolutely correct.
He has come to this court by saying that see, section 9 notice was issued to me.
And an opportunity.
I appeared there, I was not given a chance.
And
my land is acquired. Now that is where you see, like there is two distinguishable features. One is the issuance of section 19, another is claim for reference under section 30.
Then your Lordship will have to go to my para 15, where we have taken a specific stand and there is no rebuttal to that. our stand is this: the notice was issued inadvertently by applying wrong facts based on GG.
That is why right from the beginning this court is asking
So
that what right will accrue to a person
Yes.
consequent to the issuance of section 9. Now which way you can precisely answer this? Where
Lordship, the answer would be had the source of section 9 would be EAC and as per the declaration. The declaration you can trace the declaration based on 4 and 6 based on EAC report. See, there is no report binding on the government or on
what
the
the law
collector.
says, what section 9 says
Section 9.
of the act? Let us try to see what is the prerequisite of section 9 if it is determinable from there.
Notice to person interested.
Yes.
Lordship, 2 is very relevant. Such notices shall state the particulars of the land so needed. In the notice, there is no particular stated.
Now if you see section 8 before you come to section 9,
Lordship,
the issuance of notice under section 9 is caused by preparation of marking of land, identification of land, as has been indicated in section 8.
Lordship is correct.
See, the section 8 says just say the collector shall thereupon cause
Cause the land unless it has been already marked
out under section 4.
to be marked out. He shall also cause it to be measured, and if no plan has been made thereon, plan to be made of this.
Now just stop for a while.
Lordship.
It is admitted that section 4, his name is not there. Now whether in pursuance of section 8, whether the land of the petitioner was identified or not?
No.
By the collector?
No, Lordship. Because
now, how do you determine that?
Lordship, that EAC report.
That is first of all, anyway.
EAC report, yes.
That is the.
It's a very relevant question,
Lordship. That is for the purpose of deciding whether person is an interested person or not.
Yes, Lordship is correct. Only for the purpose of deciding.
Yes. Now, section 9, that your stand that it was issued by mistake will have to be determined then by going into those parts, those aspect of the matter.
EAC report and all the paragraph 15 of
whether you see like at all the land of such and such was identified.
Yes.
Or it was held that he was in possession or he was in occupation of certain part.
Yes. Lordship, if you read notice 9 subclause 2, and if you go to that notice, page 125, nothing of this was in that notice. So whether the notice will be notice in the eye of law, we are raising a legal issue now. But just mentioning the name and Assam type 2 and all the details are empty.
Now if you hold it,
will that be a notice?
But then if you hold it also, would it result in closure of the right?
No.
Of the
Lordship, Lordship is asking me to answer a question that would be secondary for the simple reason whether if there is no compliance at all. And our stand is this is based on GHDC. Nothing about the details about the compensation is mentioned. Only Assam type 2 and UOP 190. So whether the notice itself will be notice in the eye of law.
The notice is for the purpose of making a person know that there will be hearing on such and such day.
Lordship is correct, but section 292 details is not even whisper has been there in the letter.
That is all right. That is okay. But
the court has to court may take a cognizance of
that. That will not make this.
That is not relevant. Lordship is correct. I'm aware of that. I'm aware of the submission I'm making, Lordship. But what I'm saying is this: that our stand is very categorical. That all this thing was based on GHDC, not on EAC, and EAC followed from 468, and 9 was a mistake. And then when he got an opportunity, he asked. He never appeared and asked for a time. He's never produced any document. No, if he was diligent enough, Your Lordship, he never even appeared, filed an application before the award was passed, or no hearing was done. That kindly give me an opportunity before award is passed. No, from 2013 till 2017, there is no whisper what he did, where he approached. Nothing is there, no whisper. Except in a prayer, he is asking the state to pay compensation, suitable compensation.
Shankarish, when did you come to know about the award? When did you come to know about the existence of the actual award?
The award.
Here in this case?
Let me refer to one of the page.
No, when did you come? When it came to your knowledge that there exists
The award.
an award prepared in this matter?
Your Lordship, kindly see para 30 of my writ petition. We stated that we were informed that 80% was released.
Para 30.
Para 30.
So that means at the time of filing of the writ petition, you were in knowledge.
My Lord, since how the landowner would know the order passed and keep in the record of the collector until they publish it. Lordship, is para 30. Therefore, it is humbly submits that the action of respondents they decided arbitrary and unconstitutional. Needless to say that on the basis of the land valuation market value of the land fixed by the Provincial Respondent Council, the respondent collector passed the award without application of mine and released 80% of the compensation to the other landowners in the year 2013-14. The above awards so highly illegal for the simple reason that the Provincial Council.
You are reading which part?
Para 30, my Lord.
Para 13. 13.
30. 30. Lordship, got it. Running page 19.
So your writ petition discloses that you had the knowledge of this thing.
We were given the impression that the award was passed on the basis of the District Council assessment. So we are saying that this is illegal.
I think now you know, but then there is still a scope of filing an application for reference under section 30.
Section 30 now. Your Lordship, please, therefore the prayer.
That is what, see, because what kind of relief you expect? Even if you accept your contention is correct, there is some you see, like legal obstacle. We cannot go to that extent granting
Section
compensation in this.
My Lord, my prayer in the writ petition is to pay compensation. Now, even if we invoke section 30, therefore, to invoke section 30, settlement of the award is important. That's why that question arises. And the award order furnished by the collector, Lordship, kindly see page number 5 of the paper submitted recently. Lordship, just kindly see.
The problem is that
Yes,
you see this court is basically still not about what kind of, still not you see, like sure about what kind of relief can be given to you. That is what the problem is, because we have to place some law and all showing that in violation of section 9, that is what the court.
Yes.
But see, but then the problem here is totally different. There is nothing, but then just mere issuance of section 9 is not proof of your ownership of your land, not proof of your ownership over the land.
Yes.
Yes, what you are trying to refer?
Page number 5.
Which one? What?
Page number 5.
Which the this
Of the compilation submitted by the learned GA last time.
Was there any compilation submitted?
The letter dated 10 May 2024, addressed to Mr. Sen Gupta by the collector.
Yes.
Lordship, kindly see
page
5.
Yes.
This is the order and signature of the officer. My Lord, kindly see, peruse the case record pertaining to ALA case number such from Songsak to such. It appears that the stage for preparation of draft award as date of declaration under section 6 of the Act 1894 is published on such in the Gazette of Meghalaya and such Shillong Times and such in the Salatani. It is a local paper in Karo Hills, and subsequently taking possession of the land invoking section 17 of the such of the Act on such. Though possession of the land was taken earlier, invoking urgency clause under such, 80% compensation was paid under section 17 such of the same Act award is not final as per Section 11 and 11A of the earlier Act. As per Section 24(1)A of the new Act, the provision relating to the termination compensation as per this Act will follow. Therefore, prepare the draft award with sections and such. Compensation has to be determined as per provision of Section 26 to Section 30 of the new Act, allowing solution to the amount of compensation calculated as per subsistence and such, interest and such. Draft award so prepared be sent to the Revenue Department, Government of Meghalaya, along with the relevant records document for further scrutiny approval. Now, the second page is not punishing, where he would have put his signature and the order.
So this is the record is there with them, isn't it? We have the record.
Where is the second page? So it clearly shows, my lord, that they have taken the initiative under the old Act, but the compensation was determined on the new Act.
Which way we determine the order of the date of the order of this order?
My lord, here it is not reflected. Lordship, kindly see page number 2 onward.
And then what are the
Award
pages?
statement.
This thing, this is the apportionment of compensation, isn't it? Then second is the list of the beneficiaries.
List of beneficiaries. And in my, though Lordship may not cannot decide this, but I would easily point out where my land is situated.
No, that's okay, but then this we are not interested to
Yes.
know, Mr. Sandesh.
So Lordship, kindly see page number 2. Award statement.
Page 2.
Page 2. Page number 2.
Yes.
My lord. This is the award statement. We will continue, my lord. And Lordship, we kindly come to page number 4. See in the column number 16 on the top. Total amount of compensation, page number 4.
Yes.
Awarded for compensation for acquisition of the land in question is 8 crore something.
Yes.
Amount already paid under section such and such.
Yes.
So under the new Act also they have released certain amount. And now total amount of compensation payable to the persons interested under this award, such and such. Now when we travel down, my lord, number 20,
Yes.
total amount of this award including establishment and contingency, this one, and date of this taking possession of the land under section 16 such is 30 September 2013. So this is the award statement. Normally collector should have reflected the date of his award. Immediately it is not there. And now he's noting the new Acquisition Act. So award perhaps passed after 2014. Because a new act came into being 01/01/2014. This is a new Land Acquisition Act. And award is not mentioned. Date of award is not mentioned.
It's very
So it is
interesting. See,
circumstances,
this
my
order
lord.
also there. The order also order sheet. There is no reflection of date. In the award also there is no these things.
Right. And therefore, with due
The
respect,
amount already paid under section 17 is such and such.
Yes.
Till which date? We could have assumed that till the date of the preparer of this amount, this award statement, when there is no date in the award also.
no date also. Now,
Can
that's
we clear the
how
entire
citizen
amount,
will know.
this thing amount?
Lordship, that we have to ascertain, but most probably I don't know. At the moment, Your Lordship, I
That is the
can't.
problem, Mr. Khan. We will not be able to reach any conclusion here in this matter.
It's very unfortunate, Your Lordship. You know, I'm aware of it. That's why I'm making
I
honest.
do not know which way the official records are maintained. Just give us the original part of that order which you have entered this thing. The order which has been enclosed, which has been read out by Mr. Sangresho just
Page
now.
number 5.
Page 5, Lordship.
Just give us the original part of the page number 5. We'll just see what is the previous date of the official noting in this and what is the subsequent date. At least you can assume that the period is in between some.
Right. Lordship, kindly draw the
No, but then this speaks about preparation of draft award.
draft report.
We must know about the finality.
Final award.
Yes, that is
But it is copy is not
draft.
save is not
There may be draft. Government may not accept it.
Yes.
Then how do you know when it has been accepted?
My lord, therefore, when the author of the collector himself do not know the date of his award, how the citizen will know the date of his award?
You see, how many records are maintained so far as the law? See, this land acquisition concerns. The collector has his own thing.
Yes.
But then once a draft award is made, and forwarded to the government, whether government maintains another record?
Lordship, government maintains the revenue departments. They maintain and they approve in form of a letter.
Okay, so while approval is made,
Yes.
there must be noting in the official file.
Yes.
Do you have that?
That
This is the one by which letter it was forwarded to the Deputy Commissioner, the draft award.
approval, government approval.
It was sent to the government by the Deputy Commissioner with the draft award.
And then
So,
after draft
and
was
then it followed.
and draft was approved.
Yes.
Draft was approved.
Yes, here it is.
Yeah, Lordship can just
Kindly point out that thing. This same that order.
flag mark. That order is same, Lordship, even in the original record. Nothing.
What is the previous of that?
Yes.
Previous date of that file noting. Just pass it to us. Let us see. We do not know which way these files are maintained, and why it is maintained like this.
Forwarding of the award. ये कहाँ है approval कहाँ पे?
Joint Secretary. See, this is the approval. It was placed to the government. These are the file notings. They are to the Deputy Commissioner.
$25,500 2000.
It was forwarded for approval.
Your Lordship.
And
And
then-
then this is the file noting, Your Lordship, where the government has approved. Original copy. So 25.
And publication is done by which manner?
Publication.
The publication of award, how it is done?
It has to be done under Section 12. So once this approval, Your Lordship,
No, practically which way you make it?
they make it. I think the collector publishes in the newspaper, in the office,
Was there any such publication made?
as per the record. No? It is there. Section 12.
Section 6.
Section 12.
Not Section 2.
No.
It's not reflected.
So how can you say it?
At least the approval date, Lordship, on the left side top. That date we can get.
No, but then where is the approval? There is no approval here.
Signature, Your Lordship. That's what? Signature, no?
Signature of?
The Joint Secretary.
Joint Secretary.
No, this.
Normally, this is a file, Lordship is slightly technical.
No,
we
this
may
is-
not be of great assistance, Your Lordship, because the file noting. The
See, the thing which you have referred just now. $28,500.
The file noting, Your Lordship, even I'm not much acquainted how they note down. Signatures are small, and so leave it to the person of the court. वो स्टेटमेंट कहाँ था जो उसमें था ना स्टेटमेंट जो
There appears to be a correndum to award also. Mr. Khan,
Lordship.
kindly see thereafter this office note pages 26.6 and all. Corrigendum to the award that has been approved.
Normally, you see, whenever draft copy is given, Your Lordship, whenever draft copy is given, something.
No, after the final, after approval, there appears to be again corrigendum.
To the award. So,
Yes, definitely, that is what it's saying here. It will be difficult for this court to compile all the facts.
But Lordship, to give a specific answer, Lordship, if I take
See, this is basically what this court basically at this stage is inclined to afford an opportunity to the petitioner, and most practicable by virtue of section 30, if we have any scope to do that.
Absolutely, Lordship. But Lordship,
There is no question of going back to the stage of section 9. Now, if at all the petitioner asserts that his land was taken and all, he must file an application to the collector seeking referral of the matter under section 30. Now,
Lordship is correct.
if that be the thing, that will be reference under the old act. Now, who will be the land acquisition court at this stage?
The special court there, Lordship.
Now, the court, special judicial officer, now this thing is nomenclature is different. It is not special judicial officer. But then award is under the new act. Now, what is the corrigendum?
Lordship, if I may just take first to, I think, page 26 of my this will clarify all this application, Lordship. The paper compilation.
Which you submitted earlier.
Lordship, yes.
Lordship, but then what about this office note here?
Page.
Turn to the back side of your flag mark. And just see that page 36 of the thing. It speaks about a corrigendum. Then where is that corrigendum? You have to see to what extent you have done what.
Lordship, as I submitted the official note noting.
See that office note and just see.
Lordship, in the meantime, if I just take to page 26, Lordship, at least.
You please go through this, and then I do not know whether.
Page 26.
Just see your 30 page 35. The page
35.
35 or 36. What is that? After the flag marking. After the second flag mark, the reverse side of the second flag mark. See the note, office note below. It speaks about a corrigendum. Order passed sometimes in June.
Clarification or corrigendum to the award. In the connection we discussed with Principal Secretary modified draft placed before for approval. This is 26/6/2015. So Lordship, the word used is clarification or corrigendum. For clarification.
Yes.
And
what happened there?
And Lordship, then I'll come to page 26, Lordship. The answer is in page 26.
At page 26 of?
My compilation.
So we can return you that this original documents.
Lordship, yes.
Yes.
So this was Lordship asked me to read. This is 26/6/2015, and the final whatever clarification sought has finally been decided by the government. That was around 8 July 2015.
Yes.
8 July 2015.
Yes, page 26.
26.
Yes.
So this is from Deputy Secretary to the Deputy Commissioner. Acquisition of land for construction of 2 lanes, Shillong, so and so. Reference letter 16/6/2015. In inviting a reference to a letter cited above and in partial modification of the department letter 1/6/2015, I am directed to say that the approval valuation of compensation of the award is in respect of the above mentioned project is as per detailed below. So this was the final approval given by the government. An amount of rupees 3 crore 62 already paid to the landowners. Therefore, the requiring body has to place additional amount of 5 only with Deputy Commissioner. All formalities are completed. Kindly inform government of the following: date of disbursement of land compensation, taking and handing over the possession of land, name of the awardee. These are the formalities required when the Deputy Commissioner publishes it. So to clarify that corrigendum or clarification that was addressed to and final decision government is taken.
So the award,
right,
which was approved was subsequently modified.
And Lordship, we take 8 July 2015 as a date of approval by the government of the award. So we can go technically, there was a draft award without date, but we can take safely 8 July 2015 as a date of approval by the government. Subject to any further queries by the court.
Now the problem is that is there any provision like section 30 in the new act?
There should be.
Do you have the new?
We have the new act.
No, it must be
76 of the new act.
76.
76 of the new act.
Does it let down any time?
Same is a parameter.
There is no time stipulation.
Yes. And Supreme Court decision is there, my
So
lord.
then what happens if you file an application under section 30?
Well,
That may perhaps solve the things by avoiding all those technical errors.
that is also clear. Your Supreme Court order, it says that there is no time frame under section 30. It should be reasonable. Worship, I have cited the judgment also. Because in the earlier occasion, this
No, it's an
Lordship
admitted
put that
fact.
query.
Section 76 or 30 does not talk about time. So it's not an issue.
So, yeah,
unlike
2007.
18.
Madam. Yeah, 2007.
So Lordship, that was one of the reasons. Lordship, when the single bench passed an order and Mr. Prasad made a statement, inadequate compensation. So I had to concede before the division bench that if it is an inadequate compensation, the remedy lies under section 18.
Definitely.
Lordship. But then subsequently a different argument was forwarded in the last paragraph that there is no compensation at all paid. And liberty was given by the division.
Everything resulted out of the wrong submission given by Mr.
Lordship, yes.
That time.
Absolutely correct. So I had to say that.
And you took the opportunity of that wrong submission to get the matter.
Lordship, I thought maybe I could hit a bouncer.
Okay, you have done the duty of a lawyer.
But then when division bench says refer the matter back to
Taking reference of the matter.
or at the best, Lordship,
Definitely,
that some other approach the collector as per and file an application under appropriate provisions of law.
That is all right, but the thing is that in which manner you should approach, what he should write there and all that.
That is fine. But Lordship, one finding is very important that I will request this court to at least observe. That no documents has been produced even before this honorable court. Regarding the title and ownership. At least that part is very crucial.
When there is a claim of compensation.
When there is a compensation.
So we can dismiss their petition saying that nothing.
Not dismiss, but that is an admitted fact.
No, then we can say that is the petition, that though prayer has been made, but then no sufficient document has been annexed.
That is a settled position.
Allowing this court to assess the
Lordship, that would be an argument whether if they want a writ of mandamus.
Yes, Mr. Samani,
they should have an enforceable right.
How do you support?
There is no subsisting right.
No
subsisting right.
Of documents which you have annexed.
My lord.
NOCMA certificate
Prayer
only.
is for compensation. Now assume that this court is inclined to give you compensation. Now how that, what direction, what basis this court will pass a direction?
My lord. Now the settled law, it is settled law. Even writing a representation to the chief minister can be considered as a reference of the section 19. Citizen do not need to.
We are asking you about the prayer made in the writ petition.
My prayer in the writ petition, my lord, it is complete. My lord, I ask for directing the government to take appropriate steps. I don't need to quote, my lord, the section 5, 6, 7, 8, 9, 10.
No.
Lordship, kindly see.
What you say is that grant compensation.
My lord, Lordship, can you see? Two prayer, my lord. Direct the respondent state to take immediate steps. But the steps will be in accordance with law, my lord. And pay compensation.
Yes.
But, so my humble
that is
submission.
for step for paying compensation.
Yes. So my humble submission is, my lord, my prayer is comprehensive enough to include even section 30, if Lordship deems fit. 9 also, my lord. And we have given the impression that land acquisition was under
immediate steps for paying compensation, isn't it?
My lord.
Then, what the steps would mean?
My lord, the step would be in accordance with law under the Act. My lord, we have mentioned, my lord, at the bottom of my prayer, we have quoted all act. We have given the impression that it is under the all act. Now, by
That
the
is all
own
right,
choice
you
of
see,
government,
no issue
it's a
on that
new act.
thing.
So Lordship, Lordship can demolish the relief, make it clarify. This take away Lordship power. I was surprised to see that the litigants quote the section for seeking relief. That would be super technical on the part
What
of
is
the government.
the status of payment? Whether the entire amount is exhausted? Because ultimately it comes to, if it comes to apportionment,
Lordship, we have not sought for instruction on that.
say supposing even if we pass some order directing him to approach the collector for reference under section 30. Now section 30 will be for apportionment, isn't it? Now already an amount has been sanctioned.
Lordship is correct. Absolutely correct.
Now if his land falls within that area, it means that his amount has been received by somebody else. In such a case, there has to be a process of recovery now, which is not possible, isn't it? So that is why whether that is this court is basically interested. This is interested to know at this stage whether this entire amount has been disbursed or not.
Lordship, we need instruction for that at least. That we have not sought. We have not sought instruction because that was not the issue. Never involved in this case.
Yes, if we make a direction, Mr. Sangresho, to approach the collector seeking a reference, then what happens?
Well, if Lordship direct the collector to refer my matter after receiving my application, then the reference court will decide.
Lordship, not
Reference
to
court will decide. But my first prayer is
not to refer the matter to refer would be giving mandamus to collector.
Here is the
Please give him
case.
No, it has to be reference. You see, collector. This is we cannot say we cannot direct.
Absolutely, absolutely. The submission made is direct the collector to pay compensation. I mean that would be assuming the power of his application would be like here direction mandamus would be an issue.
As a clear-cut direction.
Absolutely,
The collector.
decide as per law. That's why I'm making a submission.
Certain discretion vested in him, we cannot exercise that power.
Yes.
We may direct him to consider and dispose of your petition in accordance with law.
Absolutely
But
correct.
then we cannot tell
Absolutely
him
correct.
that you have to refer it.
my lord here. Well, even the collector himself.
See, even if you make out a case here, we cannot pass this continuance until unless there is a case of rejection by him. If there is a, say, like your application was filed and it was rejected, and then there you come, at this stage you come, then maybe we may direct, saying that his rejection was wrong. But then so long he exercises his discretion, we cannot say, or you cannot interfere there. That is a limitation.
Therefore, my prayer is twofold. My first prayer is, in these circumstances, this honorable court even direct the independent person like a district judge to ascertain the facts on the ground and give a report to this honorable court, and this honorable court can pass appropriate order. There's one option.
When see, solution is available under law. Any relief to be granted in a litigation matter, it has to be in accordance with the enactment, not by traveling beyond that.
That is true. But when the land of the citizen is taken away without any due process of law, that is one option. And another one, Lordship inclines that there is enough inbuilt provision in the LA. Therefore, I can invoke Section 30.
See, the thing is that in an acquisition proceeding, if you allege your land is taken, the proper course is approaching collector seeking a reference. You have not done.
Correct.
Admittedly, you are satisfied with the issue of Section 9 notification, and therefore also whatever you have done, it is still under shadow.
Yeah.
This court cannot determine. Though you say that you appeared, your representation said that you have left voluntarily upon being informed that your claim paper was not found. Okay. Now these are all factual aspects. Now if you had to take into consideration all those things and all, then this court basically is like a bit hesitant whether you can be relegated back to the stage of Section 9. This court is probably once award is prepared, though there is no date mentioned in the award, but then the fact remains that there is an award in existence. So there is no question of relegating yourself back to that thing, Section 9.
When we see Section 13, 19 and 13, collector has the power to correct the error appear in his award. And collector has the power to correct the change or pass the
Your
award.
thing is not an error.
Well,
Error is something apparent, isn't it?
but something apparent. Something
Yours is a
apparent.
claim.
Therefore, my lord, collector, what I'm trying to submit is that collector has every power to pass an award in my favor. Because till date, there is no award in my favor. He might have passed an award in favor of the remaining 120 landowners. But in my case, no award. Therefore, in my case, if he passes an award, that amounts to passing a fresh award in my favor. Not altering the other award passed in favor of other landowners.
This is, see, one thing is that once an award is prepared, that is basically the conclusion of the proceedings. So once proceedings is closed, until and unless there are some correction, probably which is basically there on the basis of the materials on record, probably that can be done. But then to entertain a fresh claim and to modify the award accordingly, I don't think that is possible. Then it will be in a way negating section 18 and section 30. That will be a kind of exercise of power by the collector.
But my humble submission is collector has the
See,
power. Has the power. And now the learned EAG.
No, the collector has power to entertain a claim which comes after the preparation of the award.
Award, my lord. My humble submission.
So, any law on
My
that?
humble submission, if any landowner lose his land and subsequently satisfy the collector would have definitely authority to pass now.
The question is that after the preparation of the award, the collector's power to entertain a fresh claim. Just show us. Then we'll agree with your submission.
But in that case, my lord, I'll try to see, my lord, within a week's time and apprise this. I feel that it should be. Collector should not be, my lord. Collector should not be
Principle of
restricted to that.
justice may say many things. We may not, without following the procedures, we may say that yes, let us come to a negotiation, Mr. Khan, Mr. yourself and the court, and let us pass some.
No. It should be in
Then we
accordance.
cannot
with
do it that way.
Right, exactly.
Now, then, whatever your submission, now the submission which you have made just now is basically concerning the power of the collector to entertain a claim. Consequently,
And he has the power to pass the award. Even if Lordship do not incline to that prayer, Lordship may even
see, this is in view of section 30. If the collector still has the power, definitely this court will say, will send you back to the collector and direct the collector to take the action in accordance with it. But then the law contemplates that in such a situation, it is for the special judicial officer to discuss. Because rightly or wrongly, your claim before this court is after preparation of the award. Your writ petition speaks about the award. So that you have approached this court after the award is prepared. Now once that is the thing, then the only remedy lies is section 30.
Section 30.
Yes.
Now under section
There
76.
is no other remedy.
That would be my lord, alternative prayer. First prayer is Lordship has enough.
That would be the most proper prayer. See, if at all your assertion is that section 9 creates a right in your favor, then your prayer should be for setting aside the award. You are not doing that. What you want, that inclusion of your claim in the compensation. You come back to section 30. Yes, Mr. Khan, what do you say?
That one is there.
No, that's a very valid suggestion from the court.
We do not know. We are just saying this is what is there in mind. So, if there is something wrong, then you have to point it out. You have to correct the court.
Lordship, I will not persuade myself to say the court is wrong. But we can disagree. They are proposition of law. But what is fallen, Lordship, is that they should have.
No, that is what appears to be a situation. Yes. You see, that is why I see like this court repeatedly was pointing out the situation existing prior to the preparation of the award and the post award.
Absolutely correct. In fact, Lordship, if I may submit, I'm really grateful to this court because we never had an occasion to understand this part of land negotiation matter. Because what we knew, Lordship, and what the law contemplates is this: you either revoke 18 for reference or for apportionment 30. And Your Lordship, the prerequisite for that is that you approach that saying that this was a document and then the court takes a call. Our situation is that instead of after 13/9/2013 representation, they came to the High Court. There was an alternative statutory remedy available. I'm not going into that again, changing the dimension. Having not chosen that, they've just come to the court and asking the court that kindly allow me to avail the alternative remedy. That should have been exhausted first.
Mr. Sangresh, can you continue with it tomorrow? You can be able to find out that queries.
Yes,
There are two aspects. Another thing, Section 9, once a notice is issued, creates a right in your favor that you should be heard. What is the non-adherence to?
Consequence of non-adherence.
Yes.
Right.
Now, say in failure to afford you a chance of hearing, whether court can relegate back yourself to that, even after the award. Now, this is one thing you have to find out.
Yes.
If you can do it, then we'll definitely send you to the collector, asking him to consider your hearing, take up your hearing as in pursuant to Section 9. But then, if we, as Mr. Khan says, that he cannot put back the clock. Okay. Now, if we cannot do it, then that only remedy remains Section 30. But then you say this, according to you, the collector should have some power.
May suggest on Monday, my lord. Tomorrow is a Friday.
Problem is that this court has such a weak set of mind, it forgets that.
No, sir,
it's okay, then.
We are here to assist and ignite
So
the
at least
court.
both of us will have a Friday, Saturday, Sunday. It is 2-3 days to look in the day.
All right. But then in
His
such a case,
Lordship has formulated the issues very well. Either he gets a judgment that says its clock can be reversed back and relegate to that position. If not, he already had an alternative remedy and the court can direct them. In fact, without directive
Mr. Khan, rightly or wrongly, he has a claim. Whether that is worth acceptance or not, we do not know. That will be determined by the appropriate.
Lordship, for a moment, at least I'll disagree so far this query that has fallen from the court. Before the Red Court, if Lordship says rightly or wrongly he's got a claim, no, that has to be answered whether there is any pleading, any documentary evidence. We are not before a civil court, but we are before a Red Court. Now, in a Red Court, along with the pleadings, there has to be a supporting documents. He doesn't have to prove in the witness box. But let us answer that query.
Is it not that his averment is enough?
No, Lordship, no, averment is not enough. It has to be supported by a document. Because then the larger issue of transfer of property act comes. How does one become an owner? Do you need to have a sale deed? Or do you need to have a documents? So that is a larger issue, Your Lordship. I'm sure the court will not venture. At least a supporting document to say that he has got a claim.
See, the one thing is a bit different here is that there exists a representation filed by him, which you have not responded.
But again, Your Lordship, no documents in annex in the representation.
That is coupled by the Section 9 notification. Section 9.
Yes.
You say that it is wrong.
Yes.
But then you have not passed any order saying that it was wrongly issued.
Lordship is correct. But
you are raising all this is a very later stage. If you say something, see, Mr. Khan, with your expertise in this arena, you can definitely improve a case for the state.
Yeah, absolutely correct.
But then the things,
absolutely correct.
The things which you are saying now should have been a part of record.
But it's not.
All say
it's not that.
So was issued notice under wrong impression. Then in such a case there has to be a reason recorded there. Where is that?
That is missing. Yes. But Lordship kindly appreciate.
So if that is missing, that is the vital thing which is
Lordship,
missing.
by not passing an order, it has fallen from your Lordship the other day. Does it give them a right which confers them an ownership title?
We are not determining. Red Court is not there to determine.
Absolutely. Lordship, that is a vital issue.
It is enough for this court to show that there exists a cause of action. And the cause of action is that non-affording him an hearing pursuant to the issue of Section 9, coupled by non-existence of any order in your record.
Yes. But the non-hearing, Lordship, by the admission, they chose not to hear the matter.
Then there exists a representation. That also you have not disposed of. Plus your award contains no date.
Lordship, we understand. We are absolutely correct, Lordship. Not for a moment I am saying that all the procedures are perfect. I have presented the case with the inherent flaws. And there's been glaring omission. For reasons we don't know why, but we have not been able to assess the court. Had that been the case, things would have been different. But all said and done, Your Lordship, his case is very specific. He is not challenging. It wants an entitlement of compensation. For that, Your Lordship, we have to first overcome the hurdle. Whether there along with the averment, there are documents which we can arrive at, let's say there is a subsisting right.
See, do you want to say that in this kind of matter, the prima facie this court should be satisfied that whether that person owns a land or not?
Lordship, yes. Otherwise, Lordship, how can a court issue a mandamus, Lordship? Can you appreciate?
You are a public authority. Once there is representation, is it not your duty to dispose?
That is a different issue we admit. We admit, Lordship, we concede. We concede, Lordship, there's a flaw.
Several orders are passed by the Reed Court directing the authority concerned to dispose of the representation.
Lordship is correct. To that extent, I concede. Lordship is correct. Yes. But
then you have not done it. You see, this is not your case that you have not received it.
Absolutely correct, Lordship. We concede to that.
We'll continue in second half. Or you want it on Monday?
Monday, Lordship.
Monday, if Lordship
Let him find a judgment on that.
this.
In the meantime, Lordship, I'll seek instruction whether the entire amount has been paid or not.
Please. But then I think it has to come to some solution.
Yes.
Yours, what you suggest, that is the best way of doing thing. Dispose of the writ petition, a shortcut way, saying that no land acquisition has been. So petition of primary ownership.
Yes.
Petition stands.
Yes. Citizen cannot point out the limitation of the
But
collector.
that will not answer the issue of section 9.
Lordship is correct. Let's see how do we blend both the argument.
Thanks for suggesting a very shortcut way.
Absolutely. Lordship, Monday. Obliged.
I'll land the counsel for the petition. Wait, Mr. Khan, let the court pass order.
All my friends are queuing, so I thought.
I'll land the counsel for the petitions. Then you say. And the request to the parties. List this matter again on. List this matter on. Can give Monday's date. Let us try if you can finish it.
Yes.
Because this is.
All case.
No, it's hard repeatedly and then.
Right.
Memory fades and again you see. It's a problem. You can keep this copy of this order.
Yes.
Much obliged, Lordship.
Yes.
Allowed
We'll have. Yes, Mr.
Please, my lord's indulgence, my lord. But there is
Yes.
one item 11, my lord, in the hearing list.
Yes.
But if it is listed after 2
Will not be second up?
Second half, I have some difficulty, my lord. If it is taken
Yes,
up
Mr.
after
Namla.
2 weeks.
It's okay, Lordship.
Item?
Lord, item 11.
When do you want it?
Lord, it may come up after 2 weeks, my lord.
Is that all right with you?
It's all right, Lordship. But hope so it will be taken up on that day.
You're also there, Mr. Chanda? Wait. In this matter? Mr. K.P. Bhattacharya, London GA. Place for grant of adjournment. Praise for adjournment of the matter. Do not say praise for adjournment of the matter by 2 weeks. Come on, Mr. Nokla, London Council, let me with the petitioner has no objection. Prayer arrived list after 2 weeks. This is service matter.
Yes, my lord.
It was for some time it was posted before the other court.
My lord.
Right.
You did not take a chance to finish it.
We tried.
My lord,
Lordship.
then it came back, my lord.
Came back here.
Yes.
Oh, yes, my lord.
Item number 14, Lordship, we were supposed to file, bring on record the charge sheet, copy of the charge sheet, Lordship. We have received the copy of the charge sheet, Lordship. However, Lordship, I'm praying if I may be allowed to bring it on record.
You are directed to bring it on record by an affidavit.
No, Lordship, there is no leave of this Honorable Court. That's why, Lordship, I'm praying if Lordship directs us and we can bring it on by an affidavit, additional affidavit.
Is it needed or mayor's placement?
It is required, Lordship. It is required, Lordship, in my humble submission. For
He's
proper
going in a
addition.
total different direction, my lord.
I have not.
482 matter. They prayed that we want to go through this charge sheet. It was not filed. Waited for the charge sheet to come.
482 application was filed at the stage of
Before charge sheet, my lord.
before charge sheet.
Yes.
Now the charge sheet has come.
Yes.
Now definitely this charge sheet can be taken into consideration.
No, that is no problem, my lord. But it is going into totally different direction, my lord. They have challenged in 482 this. There was no whisper of charge sheet. Nothing they have mentioned.
It is connected to
But
the
during,
same.
during pendency, if at all charge sheet comes, the same can also be
Yes,
looked into.
there is no hurdle, my lord. There is no hurdle.
So that is what you see, like once charge sheet comes, that will be proper to look at the charge sheet also.
If they want,
Then ignoring it may not be proper.
my lord.
That is what is.
If the Lordship allows, I have no issue.
No, there is no question of allowing. See, that is what the law is. When charge sheet comes,
My lord.
then you have to take into consideration the charge sheet. You see, because simply interfering with the FIR.
Because there are two charge sheets, my lord. There is a question now. One charge sheet will be filed, other charge sheet will not be filed.
No,
Lordship,
other
if
charge
I
sheet
may,
is not
Lordship,
at all required here.
this
We are
matter-
concerned with the charge sheet.
Correct, my lord.
Where-
It is of the same incident. Same incident.
No, what the quashing of what is has been solved.
Lordship, quashing is
FIR
of
filed by me.
against me,
That is
Lordship.
evidence.
Lordship.
FIR
That
filed by
is
them.
the charge. That will be the only.
That is the only charge sheet, Lordship. We are praying for
That
being
is
on record.
correct, my lord. But the facts are interconnected. One part your lordship will not
Lordship,
That
that
is
will
a
be
part
taken
of
at the
hearing,
time of
Mr.
hearing, Lordship.
That is a part of
That-
hearing.
Lordship,
You
exactly.
can place it when you hear it. Do not expect him to place points which are in your favor. You will not do that. Okay. So that you
because
place.
I am facing the trial. By virtue of their charge sheet, I am facing the trial. I am appearing in the court regularly. And they have come for quashing my FIR.
Because they are not wrongdoer, so they are fighting.
Right, my lord. Absolutely right.
Okay, Mr. Chanda, Learned Counsel, have you heard the petitioner submits that petitioner submits that a copy of the charge sheet. Of what case? Just give us just the record.
GR case number 54 as of 2023.
This is 203, is it?
203, my lord.
20.
Oh, yes, 203. It should be 203. It was wrongly referred as 202 previous.
Lordship, and it was corrected, Lordship.
Yes. Now, Mr. So-and-so, Learned Counsel will appear with the petitioner submits. The petitioner prays that not consider the petitioner prays that the petitioner may be permitted to bring on record the charge sheet filed in connection with Southern PS case number 202 within bracket 2022 by an affidavit. How long will it take?
Lordship, 1 week is sufficient, Lordship.
1 week is sufficient. All right. Okay, the prayer allowed. Oh, this is met after a week. Yes. Anything more remaining?